oral argument here in Philadelphia. As you may know, because I say it all the time, the Pennsylvania Supreme Court is the oldest appellate court in North America. Our roots date back to William Penn's Provincial Court of 1684, and our Supreme Court was officially established pursuant to the Pennsylvania Judiciary Act of 1722. Last year, we celebrated our historic 300th anniversary here in Philadelphia. We are privileged to sit in 3 historic courtrooms, Harrisburg, Pittsburgh, and City Hall here in Philadelphia. Construction on this building began in 1871 and took 30 years to complete, longer than the Great Pyramid. It was designed in the French Second Empire style. For nearly 15 years, City Hall stood as the tallest habitable building in the world. Sitting atop the building, as you have all observed, is the bronze statue of William Penn. It stands 37 feet tall and weighs 27 tons. Mr. Penn's statue faces northeast and points to the spot where he signed a treaty of friendship with the local Native Americans in 1682. Interestingly, this building would not exist if it had not been for our court. The Public Buildings Commission was established by the state legislature and tasked with the planning and construction of municipal buildings, including City Hall. Throughout the construction of the building, this court resolved issues with respect to funding, displacement of property already on site, and even the constitutionality of the commission itself. Before we hear the first case, I'd like to remind counsel of a few things. Appellant's counsel, please approach the podium when your case is called. I will then give a short summary of the case. Please begin by stating your name and the party you represent and introducing your co-counsel to the court. The justices are familiar with your cases, so I ask that you avoid any unnecessary recitation of facts or procedural history and instead focus on the main issues on which we granted review. Counsel is welcome to rely on their briefs for particular issues. Please remember that in this court we do not permit rebuttal. In cases where there are multiple parties represented by separate counsel, counsel should avoid repeating the same arguments as prior counsel. Also, please try to not interrupt the justices when they are asking a question, although I cannot promise that we will not interrupt you. A justice's question is not meant to trip you up. Rather, it indicates that there are particular issues that we want to explore further. While there is no set time limit for argument in this court, I will advise counsel when the court is satisfied that all of its questions have been answered, and at that time, I will ask that you conclude your argument. Mr. Minner, please call the first case.
Ursinus College versus the Prevailing Wage Appeal Board, Appeal of International Brotherhood of Electrical Workers, Local 98, representing the union, Mr. William P.M. III, representing the college, Ms. Catherine Walters.
In this case, we are asked to decide whether a project for the construction of buildings on a college campus financed by proceeds from the sale of municipal bonds issued by a public authority, but where the bond proceeds were transferred to a trustee to be dispersed to the contractors for the project, was a public work under the Pennsylvania Prevailing Wage Act. Good morning.
Good morning. That's a correct recitation of the facts. Thank you, Court, for your time in hearing this matter. As the honors are likely aware, the Prevailing Wage Act.
Want to state your name?
Oh, sure. I'm sorry. W. Right. Daniel Feehan on behalf of Local 98. I have no co-counsel here today. As you're aware, the Prevailing Wage Act, the general principles of the Prevailing Wage Act is that if, and the legislature has decided this, that when there are public funds used to fund a project, that the taxpayers and the public have, there's an added extra duty for the workers to be paid a prevailing wage. So what that means is that there's a prevailing wage set forth by the agreement or by statute in order to avoid the possibility that the workers on that project are not paid a fair wage or a substandard wage. Here, our argument is, on behalf of IBEW Local 98, is that the way this project was funded with Ursinus College, which admittedly is a private institution, was funded by a public body and therefore triggered the act, the Prevailing Wage Act.
Funded by the public body. So the authority had possession of the monies?
They issued the money. So pursuant to the loan agreement between Ursinus College and the authority issued bonds which was eventually sold to a private underwriter and funneled through, as the Prevailing Wage Appeals Board stated eloquently, through private instrumentalities to fund the project.
They issued the bonds. Is that the same as possessing the monies at some point?
We would proffer
For purposes of the statute.
Right. We would proffer that, and we put this in our brief, that without the involvement of the Montgomery County Authority, and I'll use the short term for that, without their involvement in this project would not have happened. Now, the authority is recognized as a public body under the Municipal Authorities Act. That's clear. There's no dispute over that. So when Ursinus went to the authority to say, hey, listen, we need some money, and then they in turn issued these bonds, essentially, well, maybe we could even call it capital, to fund this, they triggered the Prevailing Wage Act, and Ursinus knew or should have known that, but it appears that there is a way to do it this way to undercut the Prevailing Wage Act and do the job quite cheaply.
That's the question. I mean, it's tax advantaged, and that but-for argument was employed by the board but rejected by the Commonwealth Court as not consistent with the statute, not on policy grounds. And does the fact that the legislature has not had occasion to come back and change the statute after all these years of judicial interpretations argue against your position?
Well, I would argue that the Prevailing Wage Act, as enacted by the legislature, did contemplate this type of issue when it wrote specifically, and as defined in Penn National 2, the definition of public work, paid for in whole or in part with funds from a public body. You're going to hear me say that a lot, Justices, that the Montgomery County Authority was a public body and it was used to fund this project.
See, but those are two different statements. Using the authority to fund the project versus using public funds to fund the project. I don't think there's any question that the authority's financing power was used to fund the project. In fact, the General Assembly specifically authorized municipal authorities to do just that for these private educational institutions. It's in the statute itself. The question really is, it seems to be very factual and you're kind of stretching it. What public funds, what came out of the public fisc in terms of dollars that went to pay for this project? And that, I thought, was what Justice Wecht was kind of getting to, and you keep going, and maybe it's maybe it's your argument. You want us to expand the definition of public funds to include public financing.
Yes, that is IBEW Local 98's position.
And our question simply is that consistent with the statutory language?
We are asking this court to expand the definition of public work in the sense that the IBEW Local 98 feels that this is an end around the Prevailing Wage Act. Now, did the Montgomery...
There's a lot of end around statutes, and I mean, good lawyers can end around almost any statute.
Right, and that's evidenced by the multitude of amicus.
That doesn't mean we change the statute.
I understand. So our position is in terms of the funds, the Montgomery County Authority issued these bonds as almost a form of capital, and they were sold to the underwriter. So were their funds exactly coming out of the authority? Not in terms of monies, but in terms of capital that was used to fund the project. There's no dispute that's in fact what occurred.
Like these were chattel, these were like things that had value, in other words.
Correct.
But I mean, I think there's value to this, otherwise these transactions wouldn't happen. But the question for purposes of the statute is, did that mean that public funds were expended, right, or paid for? Did the taxpayers pay for these bonds?
The bondholders bore the risk of it when they were purchased by the private underwriters. So, but to answer your question, the taxpayers weren't necessarily so much on the hook, but the authority as a public body indirectly held public funds in the sale of these
I
bonds
thought it was a
to the
trustee
private
that
under.
held the trustee that held all the monies.
So that is really what the Ursinus College is arguing, is that the fact that these bonds were sold by an underwriter and then funneled through a trustee is merely a form way to get around the fact that the authority did issue these bonds for the purposes of funding the project. I mean, all you have to do, Justice, respectfully, is look at the loan agreement between Ursinus and the authority. The authority agrees to lend Ursinus the proceeds of the bond. Proceeds of the sale of the bond shall be loaned to Ursinus and paid over to the trustee. It started with the public body, the authority. So we are looking for an expansion of the act to apply to these situations, because our sense is that the contract, and again, the amicus briefs tell the tale that contractors want to circumvent the act to do the project cheaper. And that's our fear.
That's clearly the case. I mean, this is a tax advantage transaction. The question is, hasn't the legislature effectively blessed it? Aren't you asking us to essentially nullify the statute?
I don't know if the legislature has ratified this kind of behavior. That's why it's before this court. I mean, the reality is that on the face of the law, you could say that this setup was complied with the law, but anytime there's an issue of a public body involved, that's going to trigger the act, and that's our argument.
Counsel, maybe you could help me out, because I find this financing area, not for this particular transaction, but this type of financing difficult to understand. So
Understood.
maybe you could help me with this. The authority never had $23 million, correct?
That's correct.
So how does the bond transaction here create $23 million in public funds? I mean, it's not as though the authority said, look, we got $23 million sitting in our coffers and we're just going to loan this to you. That's not what happened here. So I'm just struggling with the notion as to when it is that you believe public funds were created.
Yes, and that's a very good observation. The Commonwealth Court stated that the authority's role, well, in the Willman case, which was cited by the court, it was limited to providing a financing vehicle by issuing bonds to assist in the construction of the project.
Could you pull your microphone up a little bit?
I'm sorry.
That's all right. You're taller than the last occupant.
The argument is that since the authority was in possession of the bonds and sold it essentially as capital to the underwriters to fund the project, pursuant to the loan agreement, the authority did bear some risk to paying the bondholders their money.
Well, in fact, isn't the authority the obligor of last resort?
I believe so, yes.
Wait a minute, I
There's
thought,
no
this is, I
recourse.
guess, a fact issue then, because I thought from the papers that I read that all the risk was borne by Ursinus, that what was securing these bonds was not the full faith and credit, as it were, of the authority, but rather the college.
But what happens in this fact scenario if Ursinus default?
Well, then the bondholders own a college, I guess.
Right.
And the authority has no responsibility.
Well, they could very well under the loan agreement as stated in the strict language of the loan agreement. I'm not sure the inner workings of that, but
Yeah,
it's in there.
I thought these were non-recourse bonds as to the authority, because the loan agreement or the assignment of the bond liability was made even before the bonds were issued, and the bondholders who purchased, or I guess the middle person who, the whatever the name is, the person who actually purchased them, knew very well that they were non-recourse against the authority.
That's certainly a fair argument to make, and I think
Can I get back to my question
Sure.
again? So when were the public funds created? Was the issuance of the bonds the creation of public funds in your view?
that's our argument, yes. And again, we're concerned about the public policy aspect of the way this was done.
Well, there's nothing illegal about what it was done. I mean, as I said, I mean, I struggle with these transactions always, but certainly I don't think there was anything that was untoward about the financing mechanism here.
Well, I think if I struggle to wonder why Ursinus knew or should have known that if it went to a public authority, that why it would not trigger the Prevailing Wage Act.
Well, it did it specifically to get the tax benefits. I mean, that's why. It's a tax advantage that's been blessed by the General Assembly. I mean, there's really no, as I see it, there's no dispute on the facts. It seems like your quarrel is with this tax advantage device that has apparent longstanding legislative blessing to, of course it's a fiction, but there are all kinds of fictions in the law, right? So this is a conduit that has been blessed for tax reasons. I mean, I guess the IRS might have a quarrel with our General Assembly here, but there it is. And I don't know where the authority's holding public funds here. They sold it to a the private underwriter paid, right?
Right.
Not the taxpayers.
Correct, but the capital in which the bonds were sold were funds out of a public body, the authority.
And that's what distinguishes this to me, although, like Justice Donahue, I'm not sure I completely understand the financial transactions here, but the authority was the only source of the funds which were used to carry out the construction. I mean, when you go back to the beginning.
Yes, correct. It all starts there. Without the authority's involvement in this, there would be no funding. Now, Ursinus could have very well gone to other avenues, private funds, raised tuition to do this, but they chose to go to the authority. And when a private entity wants to go to the authority and go to a public body, there should be the Prevailing Wage Act should be triggered.
And you don't care what the mechanism is. In your client's view, if a financing takes place through a public body, then public funds are at issue pursuant to the Prevailing Wage Act.
I think that's fair to say, and I think the loan agreement sets forth that it was in fact a loan from a public body.
Just to distill your argument, and you can disagree with me, but I'm trying to distill it down. Your argument, first of all, if we talk about purely cash, right, if funds is the equivalent of cash, the only cash that was used to finance this project was cash from individual investors or bondholders who purchased the bonds. That's the only cash, and that cash never went to the authority, correct?
That's correct.
So the only way you can prevail is if we hold that the bond paper that was issued, that was given value by the private investors, is a public fund, the bond paper itself. That's really the only way you can win.
I think that's a fair summation of the argument, Justice.
I think you may sell yourself too short there, but I'm not sure that's the only way this scenario results in the Prevailing Wage Act applying, because it seems to me that the why is important, why these funds were ever generated. They were generated because of the actions of the authority. The authority seems to me to have been the source of the funds,
Yes, that's
or the
correct.
source of the
Funding.
raising of the funds, the funding.
The but-for, that's the but-for test,
yeah.
but
Right.
Why is that wrong?
The authority had, Ursinus enjoyed the mechanism that the authority could provide to them by raising
So why
these bonds.
isn't that enough to trigger the Prevailing Wage Act?
I argue that it is enough. Now, the counter argument is
I
that,
think
well,
you're going to have to convince some of my colleagues that it is enough, but
well, there's
well,
no,
I did make that argument that it is funds from a public body.
that's the leap. So if it's a but-for test, which you got at the trial level from the board, I think you win, right? But as the Commonwealth Court said, the statute says funds of a public body, which, not to beat a dead horse, but is a very different thing than the but-for thing, because there's no real dispute that this wouldn't sail. Well, maybe there's another way to do the deal. I don't know.
Yeah, there's a lot of ways.
I mean, there are ways to do the deal. But this was the efficiency gain. This tax advantage conduit was the way this deal was done. And apparently it's done all over the Commonwealth all the time, and we read about TIFs and everything. So, I mean, isn't your basic complaint that really you should be taking to the General Assembly and saying, hey, folks, you've gutted our Prevailing Wage Act with your creation and maintenance of this tax device, that the two are, that the one is gutting the other, and we want you to shave back this tax advantage device. Isn't that where this argument belongs?
I think it belongs in this court, respectfully, but in terms of the General Assembly could be arguably a little more specific, that anytime you use a public body to finance a private project, that this should trigger the Prevailing Wage Act.
But you believe that since they haven't been so specific, it's within our authority to draw that conclusion?
I think that if you just use the plain text of the Prevailing Wage Act as described in Penn National 1, it was paid in whole or in part with funds from the public body. That is enough, based on my argument, to say, hey, the Prevailing Wage Act should be triggered.
Okay.
So I think that the legislature has spoken on this, at least from IBEW Local 98 standpoint.
I have one question.
Yes.
Way down here.
Yes.
So Montgomery Authority agrees to loan money to the college, and then they assign all rights and obligations to the trustee bank. So in this scenario, doesn't the trustee bank then stand in the shoes of the authority?
They stand more in the shoes of, I believe, the public underwriter that purchased the bonds. But again, I hate to beat a dead horse, but without these bonds sold by the authority, this project wouldn't have been funded. Yeah, okay. Understood.
Any other questions from the justices? Do you want to sum up, Ms. Terfian?
Yes, thank you. The Commonwealth Court, if you look at their decision, which obviously you guys have, they stated that, let me get one here. Commonwealth Court rule stated, reproduce record 217A, authority issued the bonds and under the loan agreement loaned the funds to Ursinus for the project. It was paid out of public funds. And the Commonwealth Court said if it ended there, we would be persuaded by IBEW's position. And our argument is that it ends there. That's where it ends. Respectfully, we disagree with the decision of the Commonwealth Court, and we respectfully request that this court reverse the Commonwealth Court order of August 4th and reinstate the decision of the Prevailing Wage Review Appeal Board. Thank you.
Thank you, Mr. Fian. Ms. Walters?
Good morning, Madam Chief Justice and Justices of the Court. May it please the Court, my name is Catherine Walters, and I'm with the law firm of Bible Rutledge in Lemoyne, Pennsylvania, just across the river from Harrisburg. I am here on behalf of the appellee, Ursinus College, and I have represented Ursinus since the inception of this matter before the Prevailing Wage Board in 2018. With me today is my partner at Bible Rutledge, Eric Brossman. Eric is a finance attorney, and he worked very closely with me on the briefs in this matter. Also with me today is Carl Myers of the firm of Stevens & Lee. Carl represents the Economic Development Amicus Group, one of 4 amici who have filed briefs in support of Ursinus's position in this matter. The other 3 amicus groups include 8 independent colleges and universities, the Pennsylvania chapter of a nationwide construction contractors organization, the Pennsylvania chapter, and also the Pennsylvania Chamber of Commerce group, which represents a wide variety of industries that are affected by public financing. And Ursinus is very grateful for the support of these 4 amicus groups. Now, before I get into my argument, I'd actually like to try to address some of the questions that you asked during appellant's discussion with you. And in essence, I'm going to just try to take them in the order that they were asked, and then I have some additional matters to add to that. But Justice Wecht started the questioning by asking, did the authority ever actually hold the money? And the answer, of course, to that is no. And I promise I will explain the whole chronology of the deal and when the money actually arrived and how it arrived. But in essence, issuing bonds is not the same thing. It's not equal to, it's not equivalent to actually having money. Justices Wecht and Brobson continued with some of this questioning and asked who was really on the hook should Ursinus College default. That's pretty clear based on the documents, but in essence, because the authority assigned all of its rights, liabilities, and other interests in the bonds and in the loan agreement, simultaneously with executing the loan agreement, they assigned it directly to the indenture trustee, Bank of New York Mellon. And all of this occurred on November 1st. It wasn't until November 22nd, 3 weeks later, after the authority had assigned all of its possible rights and liabilities in the bonds over to the indenture trustee, that it issued the bonds. And at that time, when it issued the bonds, the purchase price for the bonds was wired by RBC Capital Markets, that's Royal Bank of Canada Capital Markets, directly to the indenture trustee, that is Bank of New York Mellon. And the indenture trustee, in having those funds, stands at that point in the shoes of the bondholder.
So there's no argument, really, that the authority was ever the obligor of last resort?
That is absolutely correct. And I do want to make one comment. There is a line, and I say this not by criticism, because I am asking you to please affirm the Commonwealth Court's decision. But there is,
can I ask you to move that mic?
Forgive me.
We'll just kind of move it towards your mouth. No, the other way, toward the center of the podium.
Or talk louder.
Yeah, or talk louder, one of the two.
Okay. You see, I talk out of the side of my mouth, so I'm never sure whether I'm doing it right. But, of course, I am asking that that the justices of this court uphold the Commonwealth Court's decision. But there is a line in the decision, and unfortunately, Chief Justice Todd, you used that line in introducing the case today, and it talks about the concept of a transfer of funds. And so some references have been made to the bond proceeds as having actually been transferred from the authority to the indenture trustee. And there are also other references to the conduit authority serving as a pass-through for the funds.
That was Judge Womack's language, right?
I understand, and that's why I'm saying I still want to uphold that
The problem
decision.
is, it's just a nominal issuer. Pursuant to the documents, the transaction, it's fictive. I mean, it's a tax, it's a tax device. So they're the nominal issuer. The underwriter steps in on the same day in the same transaction, buys it. There's a trustee on the indenture, and then people buy these bonds or they don't. Right?
Yes.
So
The concept of transfer, forgive me.
the what?
I was trying to say the concept of transfer suggests that the authority had the money, and it never did.
So how should the language of Judge Womack have read?
It should have basically said that the authority assigned all of its rights and obligations under the bonds directly to the indenture trustee 3 weeks prior to the issuance and purchase of the bonds.
See, I'm still obviously open. I haven't formulated my final decision, but I think the union's argument might be stronger if as I think Justice Wecht so eloquently stated, if the full faith and credit of the authority was somehow backing the bonds, if there was some risk to the authority. But everyone in this transaction, from the authority to the people that bought the bonds to the college, and most importantly, the people who bought the bonds knew that they're not really buying bonds of the authority. They're buying authority paper for a debt that is secured by another party.
And absolutely, and if anyone who purchases the bond and anybody who looked at the transaction would see that on the face of the bonds, it specifically disclaims that the full faith and credit of the authority, the county, or the state or the Commonwealth of Pennsylvania are backing these bonds. It specifically states that the authority has no taxing abilities, and indeed, under statute, under the Municipality Authorities Act, the authority has no right to pledge the full faith and credit.
Does the authority bear any transaction costs, be they counsel fees, investment banking advice? In excess of the $25,000 floor, did the authority have such transaction costs?
There were transaction costs, all of which were paid by Ursinus.
All of which were paid by Ursinus. So did the authority go out of pocket at some point and get reimbursement from Ursinus?
Not one
or everything
red
was
cent.
funded by Ursinus?
Everything was funded and paid for by Ursinus. The authority spent no money whatsoever.
Counsel, the tax implications of this.
Of course, this is a tax-exempt revenue bond issue.
What taxes are exempt?
In essence, what it means really is that the interest on the bonds are tax-free.
Yeah, I know, but if they weren't tax-free, to whom would the taxes have been paid?
Well, because this tax exemption comes under both federal and state law, and I'm just trying to respond without being particularly knowledgeable about tax law. But I would say that it's both under both federal and state tax law, and because this would be income.
How about county taxes?
I can't speak to that, Madam. I apologize, but I can't
Because
speak to that.
if the county is losing tax revenue as a result of this, doesn't that implicate public funds?
Well, you can't lose something you never had.
Well, but the reason that this entire transaction existed was to create the tax exemption.
Well, it was.
If this was financed another way, and I'm interested in somebody telling me how else this otherwise could have been financed,
Let's remember.
then there would have been tax implications. and taxes would have inured to potentially the county. And I don't know, maybe it doesn't have to be the county. Maybe the loss to the state of tax revenue implicates public funds.
Well, again, you can't actually spend something you've never had. You can't lose something you've never had.
But that's because this was created so you'd never have it.
Well,
I mean,
remember,
you can't have both sides of that coin. I mean, the reason this was set up is so that these were tax exempt. And throughout the briefs, there's a consistent strain. This could have been financed otherwise, in response to IBEW's argument that this couldn't have been done without it. How else could this have been financed? Just for my edification.
okay, well, I'll try to answer that. There are multiple ways of doing private financing, but, the thing that has been happening in Pennsylvania since the initial decision by the Prevailing Wage Appeals Board is that entities that are seeking municipal or tax-exempt funding are simply going outside of Pennsylvania. And they're going to two separate types of entities. One is called the Public Finance Authority in Wisconsin, and the other one is called the National Finance Authority in New Hampshire. And those authorities are more than happy to take the business away from Pennsylvania and to do the financing and issue the tax-exempt bonds because they will get fees, and they will have something added to their portfolios. So, yeah, there are multiple ways of doing this kind of financing, and one of the reasons why expanding the Prevailing Wage Act to cover private projects like this would be a terrible thing to do is because this is exactly what they will be doing. I've made friends with a ton of bond attorneys who call me on a regular basis now asking, should we get our clients to go outside of Pennsylvania for bond funding?
Well, you explained to me that apparently the only other way to do this is through some other tax-exempt funding mechanism. Is there a way to do it where the earnings on the bonds, the interest on the bonds, are taxable?
Well, certainly, and in a case like that, they would have a much lower interest rate. Excuse me, a higher interest rate.
Well, corporate bonds, right? I mean,
Yes, we could do corporate bonds. Do
And then
private
there would be
bank
tax
financing.
revenue flowing to the state from that type of
I
transaction.
can't say that that's accurate because I don't know. I'm not arguing
I
with
don't
you
know
about
either.
it.
I'm asking the
but
question.
let's remember that the Municipality Authorities Act created the ability to create these authorities. Now, the Montgomery County Higher Education and Health Authority is a conduit financing authority. It is not an operational authority. And as a result, it was created specifically to provide or facilitate conduit financing for 501c3 projects, just like the Ursinus Educational Institution project.
Counsel, you said that it would be a terrible thing if these projects had to go out of state for funding. Could you just elaborate on that?
Well, in essence, and I believe that this is dealt with in one of the briefs, but there is accretion to Pennsylvania to be able to engage with its communities, the various authorities, whether it's a county authority or
So this is a policy argument.
It is more of a policy argument.
Well, isn't there a countervailing policy that workers should be paid a prevailing wage if applicable?
And that is exactly why the Prevailing Wage Act exists. And please understand that we are not arguing that the Prevailing Wage Act should not exist. We are not arguing against its efficacy or benefit to workers who are on public projects. We are instead arguing against expanding and extending the Prevailing Wage Act to a private project like Ursinus. So when we look at the Prevailing Wage Act, and we look at the four prongs for what constitutes a public work, one of those prongs is that the funds must be paid in whole or in part out of the funds of a public body. And in this case, we don't have that prong met. We've got the other three, that there is certain work, that it's under contract, and that it's in excess of $25,000. But we don't have the prong where it's paid for with funds out of the public body's coffers. And so in that regard, I'd like to turn back to a topic that has come up multiple times. It came up in argument and it's come up in briefs, but it relates to the concept of drafting a transaction as an end run around the Prevailing Wage Act, basically with the goal of circumventing the act. Now, I will remind you that this court in 500 James Hance Court in 2011 said that even if an entity attempts to paper around the law, the teaching of the James Hance Court case is that labels do not matter. The loan agreement label on the document of November 1st, which was immediately assigned to the indenture trustee, that label is nominal. And in essence, labels don't matter. What matters is the economic reality of the transaction. And as a result, we look at where the potential risk lies. In this case, the authority did not pledge the full faith and credit of itself, the county, or the Commonwealth. There is no recourse against the authority, the taxpayers, or any other entity except Ursinus. And remember, these are revenue bonds, and they are funded and secured exclusively by the revenues of Ursinus College. So this deal was done, again, to use tax-exempt bonds, but not to circumvent the Prevailing Wage Act. In fact, these same types of deals have been deemed not to be public works by the Department of Labor and Industry for decades, for more than 2 decades. And this is because no funds of a public body are used to pay for the actual private project that have been using the conduit financing. So in essence, when I say for more than 2 decades, the Prevailing Wage Board, which is the Labor Law Compliance Board now, which is where folks go to get opinions as to whether a job is a prevailing wage job, has for decades indicated that this type of conduit financing transaction is not covered by the Prevailing Wage Act. All right, so if we turn back then to James Hance Court, forgive me, but the appellant wants this court to presume subterfuge and circumvention of the Prevailing Wage Act by future, as yet unidentified entities. And this is not a good reason to step beyond the statutory construction of the Prevailing Wage Act and extend it to private projects that use private money to finance all of the projects. This does not open the door to subterfuge. Indeed, if there is subterfuge in the future, nothing prevents a grievant like appellant from trying to make its case before the Prevailing Wage Board. Here, both sides stipulated to facts of the case. The appellant, who did not even have any workers on the job, could have alleged or attempted to prove some type of subterfuge with respect to the drafting of the transaction.
Counsel, you could call, I guess you could call any tax planning subterfuge, right? I mean, anything any of us ever do to minimize our tax exposure is you know, arguably subterfuge. As SCOTUS said 100 years ago that that's, you know, that's completely legit, right?
I understand.
And isn't Mr. Myers correct in his brief for the amicus PETA, is that the acronym PETA, that the legislature could, with a few strokes of the pen, just amend the Prevailing Wage Act to bring this kind of transaction within the scope of the act by saying funding facilitated by a public body, then
Yes.
Then the authority would be on the hook, right?
I agree. And that is exactly, that is part of our argument, that if the legislature was unhappy with some of the decisions issued by this court, particularly the Penn National 1 and 2 cases from 1998 and 2002 and the James Hance Court case from 2011, it had plenty of time to act, to change the law. And might I add that Mr. Myers is usually correct. But if we go further, though,
Counsel, the board referred to this as a case of first impression.
I'm so sorry.
I'm sorry. The board referred to this as a case of first impression. Is it?
I believe it is, in that it's not so much it is a case of first impression in that it is now attacking the concept of the facilitation of conduit financing and calling it public money. So the real issue here becomes, does the bond issue, I think the question was presented by the appellant, does the bond issue constitute funds of the public body? And the answer to that is a resounding no. And so this is a case of first impression, mainly because it's asking the Supreme Court to go beyond the way it has already construed funds of a public body to now say it's not necessarily funds that came out of the public coffers, it's merely the fact that a public body is involved.
So the legislature really has not had an opportunity to react to the precedents from this court to amend or otherwise deal with the issue.
Well, with respect to the conduit financing, I would agree with that. However, it has had plenty of opportunities since 2002 from the Penn National II case when the court minutely reviewed and described and discussed what constituted funds of a public body. And I would submit that it was at that point that if the legislature disagreed with that analysis, they had the opportunity to either put to rest whether funds of a public body actually have to flow through the coffers of the public body, and it could be just the but-for analysis that the Prevailing Wage Appeals Board and appellant are seeking. They had that opportunity, and they haven't taken advantage of it, and it has been more than 20 years since that case was decided. So here, you know, again, the James Hance Court teachings are that the economic reality of this transaction is that the private project was paid for with private money, no public funds were involved, and the appellant, and Ursinus, forgive me, not the authority, bears all risk of liability. If I can speak briefly about some of the rest of my argument, and I will say that my argument is thoroughly covered in my brief and the four amicus briefs, but the Commonwealth Court correctly and unanimously, I might add, held that the Ursinus project was not subject to the Prevailing Wage Act. They found that the project was not a public work because none of the monies used to pay for the Ursinus project were paid out of the funds of a public body. Now, this phrase, again, paid out of the funds of a public body, is one of the four elements that I discussed earlier with respect to what requirements are needed to constitute a public work in Pennsylvania. And again, I talk about that in the brief that relates to Penn National I, where this court specifically analyzed the Prevailing Wage Act and propounded the four elements. Again, that there must be certain work, that such work must be under contract, that the cost of the total project must be in excess of $25,000, and that such work must be paid in whole or in part out of the funds of a public body. So again, this court has also specifically held that all elements of that definition must be satisfied for the work to constitute a public work, and that was reified in Penn National II in 2002. Now, although the appellant has claimed that the Commonwealth Court's decision creates a loophole in the Act through which employers will rush to avoid paying prevailing wages, the law is clear. Really, a project is either a public work or it isn't. There's no ambiguity in the law, and there is no new loophole, or any loophole for that matter, that has been created by the Commonwealth Court. The court correctly reviewed, applied, and distinguished all of the relevant cases in this matter, and it did not rely solely on an apposite case or engage in decision shopping as alleged in the brief. The plain language of the Act is clear, and the plain language of the Act is unambiguous, and it should not be disregarded in favor of seeking a legislative intent that is more in line with what the appellant would like the Act to encompass. Now, this court has consistently demonstrated its respect for the principles of statutory construction, including the principle that the letter of the statute is not to be disregarded under the pretext of pursuing its spirit. The Act is unambiguous. The facts surrounding this project are unambiguous. No funds of a public body were used. The four requirements for finding that a project is a public work have not been met. And in essence, the Ursinus project was a private project and not a public project. Now,
That sounded like a summation. Are there additional questions from the court? I think we understand your position, Ms. Walters. Thank you both. Well argued.
thank you.
Mr. Minner, would you call the next case?
IBEW Congregation of Jehovah's Witnesses versus the Commonwealth Pennsylvania Department of Human Services.
Ivy Hill Congregation of Jehovah's Witnesses filed a declaratory judgment action against the Pennsylvania Department of Human Services, or DHS. Ivy Hill sought a determination as to whether its elders, under the clergyman privilege, are exempt from the mandatory reporting requirements of the Child Protective Services Law. In its first decision in this matter, the Commonwealth Court held that Ivy Hill had standing to seek a declaratory judgment, but denied its motion for summary relief due to the lack of an evidentiary record. Following discovery, Ivy Hill renewed its motion for summary judgment. In its second decision, a different panel of the Commonwealth Court heard argument on Ivy Hill's motion for summary judgment and dismissed the petition on the ground that Ivy Hill lacked standing. Before us, Ivy Hill raises several issues, and we granted oral argument limited to the question of whether the Commonwealth Court's second decision, in which it dismissed Ivy Hill's action due to lack of standing, violated the coordinate jurisdiction rule. Good morning.
Good morning, Madam Chief Justice, Your Honors. May it please the Court. My name is Matt Haverstick. With me is my colleague, Shoheen Vance, and together we represent the Ivy Hill Congregation of the Jehovah's Witnesses. And, Your Honors, a straightforward application of the coordinate jurisdiction rule, in fact, does require what I call Ivy Hill 2 to be reversed. We've heard, I'm listening to it too, some very...
Could you lift the mic a little bit, Mr. Haverstick?
Better?
Yes.
Some very weighty, interesting issues this term. I'm somewhat apologetic that we were mired down in a little procedural issue, but as my friend Mr. Becker reminded me earlier today, well, we'll probably make a Civ Pro professor happy this morning.
We love procedural issues, so you're in the right place.
Well, thank you. And it's important, too, because I think this is a kind of case that demonstrates sort of the rubber meeting the road aspect of the practice of law and what we all do, because this rule impacts real people. Real people in this case, in the form of the Ivy Hill congregation, who went to court to try to balance their constitutional rights with their statutory obligations, and they went to their government to get help, and their government's not helping them. They went to court. They litigated justiciability. They won. They were then ordered to engage in discovery limited to just sort of verify the facts that were in the initial pleading. They did that, and then a year later, they're out of court on justiciability. I mean, that's not fair. That's not fair to regular people. I think I'll start my discussion today with noting, and I think I can simply note it. I don't think it will be disputed by the other side, but I don't think it can be disputed that Ivy Hill 1 and Ivy Hill 2 tread the exact same ground. They decided justiciability. I mean, probably more accurately, they decided standing in that overlapping area, the concentric circles of ripeness and standing. But
That's the issue, right? Are standing and ripeness the same?
Well, look, they are. I mean, our courts have recognized over the years, as recently as well, probably, I think PWAB, but really Robinson Township, I think, is the last time I remember being addressed concretely. And ripeness is a mild subset of standing in that it can have an aspect where facts matter, but then Judge Brobson in Ivy Hill 1 dealt with the ripeness issue. I mean, he held specifically that there were no additional facts necessary that could be developed by a criminal prosecution that would make the case any more decidable later than it was at that time. So even if they are different concepts, they got decided in Ivy Hill 1, but they're the same thing. I mean, it's an old Commonwealth trick, and I'm guilty of it, as the chief will remember in Robinson Township, of acting like standing and ripeness are two different arguments that we can make to the court, and then we just kind of cross out the word ripeness and or standing, we write ripeness there, and we put the same thing in a brief. And we were mildly scolded, I believe, for trying to put one over on the court that standing and ripeness were two different things, but they're not, Your Honor.
But that's exactly what DHS did here. I mean, the arguments they made in Ivy Hill 2 were precisely the same arguments, almost verbatim the same arguments they made in Ivy Hill 1.
Absolutely. I mean,
Because Ivy Hill 1 stated what the argument of DHS was,
yes.
rejected.
Yep.
Ivy Hill 2 stated what the argument of DHS was, accepted.
Yeah. It couldn't be any more stark. And I know it's not of record, but I did, for my own purposes, one of those gee whiz things you can do with word processing where you take the two briefs and you line them up and you see where they're the same and where they're different. They're not all that much different. And both their arguments at the PO stage and opposing our summary judgment motion hinged on the notion that there was what Commonwealth Court was going to be asked to do was give an advisory opinion. They made that explicit lead argument in both cases, Ivy Hill 1, Ivy Hill 2. Ivy Hill 1 held, no, it's not going to be an advisory opinion. It's the, kind of the FOAC archetype type argument.
Counsel, can I ask you a little different question?
Sure.
Can the Commonwealth Court en banc overrule the decision of a single judge of the Commonwealth Court?
In a subsequent
Which is,
proceeding.
forget about it. I mean, just my question, not innocent. Can they overrule a single judge decision?
Well,
I mean, as I read this, that's what happened here. They
Well,
certainly didn't say they were doing that, but they came to totally contradictory conclusions.
Ivy Hill 1 was en banc too. I recall
I thought it
arguing both of them en banc.
I thought Ivy Hill 1 was single judge Robson.
I believe Ivy Hill 1 was
POs?
Was on.
It was on POs.
Yeah, I believe it was en banc. We had to do it over the TV, and I remember we had a whole bunch of black robes on the TV
Well, if that's
screens.
the case, we don't have to answer my interesting question. Okay.
It was en
yeah.
banc.
Okay,
Yeah,
I
okay.
thought so. But it's. Since we're giving manna to Civ Pro professors everywhere, I think it probably could. An en banc court could probably overrule a single judge if the issue was teed up in the way that that's allowed under the rules, like
Motion for reconsideration.
En banc, right.
Right, for the same proceeding. This was a completely separate, phase here.
Well, I wouldn't call it a different phase, Your Honor. It was a different motion. That's true. And of course, there are going to be circumstances where at the summary judgment phase, you can lose when you won at POs. But
Or if the standards are different for the
or if there are facts adduced. But if they're different, if they're facts adduced at the summary judgment stage to show that you can't state a claim. But that's not what happened here. The records were identical. Kind of by design, and stipulated that they were identical. There is no difference in the fact or legal posture of the case in Ivy Hill 1 and Ivy Hill 2, except one was a PO on standing and the other was a response to a summary judgment motion arguing standing.
May I go to the decision by Judge Dumas in Ivy Hill 2?
Yes.
She says whether a court should exercise jurisdiction is a matter of sound judicial discretion. It seems to me that throughout the opinion, the Superior Court was conflating justiciability and jurisdiction, and I wondered if you could address that.
Well, I'm going to give you my opinion, and then well, the answer to your question is no. If it was a deliberate effort or an effort to conflate the two concepts, then it's wrong, because justiciability.
I'm not saying it was an effort to. I'm just saying perhaps erroneously or without realizing it, the two concepts were conflated. I'm not arguing intent.
No, and me neither. I don't mean it. I guess let me address it this way. What I think is happening is, and if you look back at the jurisprudence, you can see loose language where jurisdiction is shorthand for a lot of different things that that aren't really jurisdiction. I mean, that's just become kind of
It becomes important.
Well, here's a case where it is important, because if it really was Judge Dumas's and the Ivy Hill 2's court that they were entitled to violate the coordinate jurisdiction rule because the analysis was jurisdictional, then the wording is important. And I think we can all accept that there is no jurisdictional component to what Ivy Hill 2 did. I mean, it was a straight-up justiciability analysis. And by the way, I don't know what species of jurisdiction Commonwealth Court has that would allow it to do anything like that in the first case. But I happen to think—
Did I say Superior Court? I meant Commonwealth Court. Sorry about that.
You have to do a lot of these. It's okay.
Thanks.
I think it's just the use of shorthand. And I think that— look, take a look at footnote 8 in Ivy Hill 2. I think that footnote is a recognition by Ivy Hill 2 that what it was doing was voiding Ivy Hill 1, because it cites a coordinate jurisdiction case. I happen to think that case, actually, if you look at it, is helpful for our argument, but that's beside the point. And then the footnote makes the point that, we're allowed to do this. We're allowed to do a contrary opinion because we're at summary judgment now, and before we were at POs.
But your point in that regard is just that it's that there's a misunderstanding here of the coordinate jurisdiction rule, because Ivy Hill 2, at least implicitly, with footnote 8, for example, is saying just the fact that the case has moved along to the summary judgment stage makes it a horse of a different color. And your point is there have to be one of these other elements. If they really felt it was clearly erroneous, they had to come out and try to substantiate that. If they didn't do that, they just basically said, that was POs, this is summary judgment, we're not bound.
Of course. All of the known and accepted exceptions that let you get around the coordinate jurisdiction rule were not cited. First of all, the facts, the court in IB2 acknowledged facts are identical. All you did was what we told you to. You went and ratified them through affidavits like we said you could. No additional facts adduced. The law didn't change. Well, if anything, the law changed in Ivy Hill's favor because this court decided FOAC in the meantime. And there was no suggestion, not even a little bit, that Ivy Hill 1 was erroneously decided or that would be manifestly unjust if it was, if it was continued to be followed. So I think the court dodged the coordinate jurisdiction rule merely by using the artifice of a different procedural posture in the case. And I think as this court has wrestled with, I think that's wrong. The sine qua non of the application of the rule is not later. Well, if it was just simply later in time at a different stage, then the rule would never apply because the second decision is always going to be temporally different than the first one.
That's the part of this that confuses me, which is why I keep getting back to this question. It could have overruled the first en banc panel if they said that it was clearly erroneous in its decision. They could have done that. An en banc panel can do that. But I'm struggling for the course that was taken here. Had they done that, then we'd be here on the merits.
And I wish, I wish, frankly, if they were going to knock us out on justiciability in the second time around, they would have done it that way, because then you're right, we could have the merits. But it can't be the state of the law in Pennsylvania that simply because you've couched your same arguments and your same facts with a different motion that you're entitled to avoid the coordinate jurisdiction. Your Honor, in your concurrence, I think we put this in the brief, unfortunately, what happened here pretty well matches up with what you predicted could happen. And it's not fair. These are real world people who are trying to get to the bottom of can we follow the law at the same time we follow our faith? It's not like they're asking for something outrageous. I mean, that's pretty basic. And they went to court to try to get it, and they're not getting any help from our government. And now they're not back to square one. They're even further back than they were before because now they're out of court.
We actually understand the case. We understand the issue.
I know.
Are there any other questions from my colleagues?
Yeah, I have a question on disposition. Assume we agree with you. What would our disposition be? We reverse the Commonwealth Court and what?
Well, grant judgment in my favor.
What would
But
the disposition be?
can I? How about likely outcomes? I think the most likely solution is to reverse and vacate Ivy Hill 2, remand it to Commonwealth Court for a merits ruling on our summary judgment motion, and then at least we'll have a merits decision that we can take up one way or the other if one of us doesn't like the result.
I guess that's why I'm asking the question. Are there any outstanding preliminary objections that would need to be decided if we vacate or reverse?
No. If the summary judgment motion is vacated, I think the court can proceed, a Commonwealth Court can proceed directly on moving to the merits of the summary judgment motion.
Okay. Do you want to sum up, or have you?
I believe that you in fact do get my argument. I don't want to waste any more of the court's time. Thank you.
All right. Thank you, Mr. Haverstock. Mr. Scarinci.
Madam Chief Justice, and may it please the Court, my name is Michael Scarinci. I'm a Deputy Attorney General with the Pennsylvania Office of Attorney General. I'm here representing Aplt, the Pennsylvania Department of Human Services, on this appeal as of right. The coordinate jurisdiction rule provides that judges of coordinate jurisdiction, or as we have here, panels of the same court, should not overrule each other's objections. But the Commonwealth Court did not overrule each other, did not violate the coordinate jurisdiction rule for two reasons. First, on the summary relief opinion, it does not conflict with the decision on POs because the panels were not presented with the same question. Second, in addition to the panels addressing different questions, the evidence presented to these two different panels was not the same. I'll address each of these two reasons in detail. First, on the different questions, ripeness was not raised on preliminary objections. We raised 5 objections: standing, failure to join indispensable parties, non-exhaustion of administrative remedies, inability of the requested relief to terminate the controversy, and demurrer as to count 2. Now, in their brief, my friend here focused on standing and the inability of the requested relief to terminate the controversy. Now, standing, as Your Honors know, focuses on the petitioner or plaintiff's interest in the litigation, whether that interest is remote or speculative. But here, the issue before this court is not on the petitioner or on the plaintiff, it's on DHS, my client, whether their interest is adverse to Ivy Hill. You made this point in Robinson Township that there can be an overlap between standing and remoteness, but where they diverge is where the facts are not sufficiently developed to facilitate judicial resolution. And the facts here are not developed because the matter is unripe.
Well, let me ask you then, because I'm trying to think of this Venn diagram. It seems here like there's maybe not as complete and utter coextensiveness as there was in Relic Smith, but
Right.
you have a significant overlap, don't you? Given that the Ivy Hill 1 was about, on the standing issue, was whether the elders would live under this uncertainty of having to report to your agency, right? And then this Ivy Hill 2 was the rightness of their claims. How in practice were those in any real way different here?
Well, again, I go back to the focus in Ivy Hill 1 was on the petitioner, whether they had an actual direct and substantial interest in the litigation. The focus in Ivy Hill 2 was on whether we have an interest that's adverse to them, meaning when you talk about ripeness, you say, is there an actual controversy or the ripening seeds of one? And by that you mean, have the facts developed to the point where litigation is inevitable and imminent. Now here, the litigation is not only not inevitable, it's non-existent. It is not possible for DHS to file a criminal prosecution against Ivy Hill elders for the failure to report child abuse. That is not our statutory role. Our statutory role is limited to being an operator and a custodian. We are responsible for Childline. We receive information of child abuse, and then we refer that matter pursuant to 6334.1 of the CPSL.
Isn't in both instances the beef, as it were, their enforcement exposure?
That's exactly their beef. Yes, their beef is. I'm sorry. Their beef is they're afraid of criminal prosecution. They made that point in their petition for review at paragraphs 47 and 48, at pages 24 and 25 of their petition review. The impetus for this lawsuit was that an Amish bishop was being criminally prosecuted, and that criminal prosecution was brought by not DHS but the Lancaster District Attorney's Office. Our statutory role is limited, as I said, to being an operator and a custodian of records.
Counsel, you raised that precise argument in Ivy Hill 1 in the context of failure to join an indispensable party. You said the prosecutor has to be involved in this case. This is all about prosecution. We don't prosecute. Ivy Hill 1 said this case is not about the role of the prosecutor. It's about whether privilege applies. I mean, the same issue that you raised was answered in Ivy Hill 1. I mean, I just don't know how you can put a different label on the same argument and come to the conclusion that you're raising a new issue. I mean, the precise issue was addressed in Ivy Hill 1.
Your Honor, my first response, I have two responses. First is I don't think Ivy Hill's actually mentioned failure to join indispensable parties in their brief. I think they focused on pages 52 and 56 of their brief on standing and inability to request the relief to terminate the controversy. Nevertheless, I'd like to answer your question. The standards for those two preliminary objection based on failure to join indispensable parties and ripeness is not the same standard. It's not the same test. For failure to join the indispensable parties, you look at whether justice can be done in the absence of that party, whether that party's interest is incidental. For ripeness, as I said, the focus is on DHS. Do we have an interest that's adverse? And I think there's a good example of that in our brief. If you look at Lewis versus Alexander, it's a Third Circuit case, and I recognize you're not bound by that, but you have looked to federal precedent for guidance on prudential considerations. You said that in Fumo versus City of Philadelphia and Rendell. And in that case, they said adversity means opposing interests. And there, the Third Circuit concluded that the Department of Public Welfare had adversity because they were charged with enforcing a particular statute. There it was Section 1414 of the Human Services Code. And so I have to go back to my point before, is that we have no obligation to enforce a criminal prosecution. That belongs to the district attorney's office.
Counsel, the problem I have with splitting hairs the way that you're doing, you could have called your argument in Ivy Hill 1 lack of ripeness. You didn't. Had you done that, who knows? But if the Ivy Hill 1 court agreed with you on preliminary objections, there would have been an opportunity years ago to amend the complaint to add the additional parties to address this issue. Now, time has gone by. The argument, and bluntly, I just don't see the pragmatic difference between the arguments that you're pointing out here. Time has gone by. Time has been wasted. I mean, that's why we have the coordinate jurisdiction rule in large part, so that we don't have the waste of judicial resources that goes into an exercise like this.
Your Honor, I think the problem with raising it on preliminary objections is based on, and this gets into my second point about the change in evidence. In their petition for review, they blanketly asserted that DHS is involved in CPSL investigations. That's at paragraph 8.8F at 14 and 15 in the reproduced record. Now, we had to accept that on preliminary objections that we're involved in CPSL investigations. But in opposition to their application for summary relief, we presented an affidavit from Amanda Doris who dispelled that allegation and showed that we have no role to play, particularly in the failure of a mandated reporter to report child abuse.
But did the addition of that element into the record vary the landscape at all?
I think it did.
Something that, for example, was that something Ivy Hill 2 relied upon in varying its ruling from Ivy Hill 1?
Yes, they did. In fact, first I want to go back to Judge Brobson's initial opinion on the preliminary objections. He noted at page 21 of his opinion that DHS disputes its investigative duties. And so we had to wait until an application for summary relief to show that we did not, that allegation was not true. And that's noted at pages 8 and 9 of the summary relief opinion.
Didn't he also say it doesn't matter what their investigative duties are, because this case isn't about investigation and it's not about prosecution. It's about the right to claim the privilege.
I think he did, yes, I think he did note some of those things, but again, I come back to it's in a different context. It's not like Relic Smith, where you have a judgment on the pleadings based on statute of limitations that the court finds is waived, and then the same party comes back and says, I'd like to amend my answer on statute of limitations. These different questions, these questions were presented in different contexts, one based on failure to join indispensable parties, and one based on ripeness. It's not even the same standard, so I don't think the court can say it's the same question if it's a different standard.
Was ripeness an issue at the time he filed preliminary objections? I mean, none of the facts changed.
Well, Your Honor, we can't raise ripeness on preliminary objections. It's not waived if, pursuant to Rule 1028, it's not one of the required objections that we have to make. So, and again, I come back to the allegation was that we had to accept that we conduct CPSL investigations. So I don't think we could have raised it without violating the standard of review on a preliminary objections.
So the holding in Ivy Hill 1 that this case is not about the role of the prosecutor, it's about whether the privilege applies, means nothing in this context? Because apparently Ivy Hill 2 thought that it was the ability to prosecute that was the issue in this case.
Right,
and it's a totally contrary analysis of the case before it.
It's not a contrary analysis because, again, the standards are different. For indispensable parties, it's whether justice can be done in the absence of that party. And for ripeness, it's whether the interests of DHS are adverse. Your Honor, there's just one or two other points I wanted to make. I think in my friend's brief, he pointed out that DHS could just pass an act of regulation to clarify the ambiguity in the law. I don't think that's possible. I think that would be overstepping our authority. As Your Honors know, this involves Section 5943 of Title 42, and that's the judicial code, as you know. And it wouldn't be proper for us to say whether Ivy Hill's elders are clergymen pursuant to Title 42. That would be the province of this court or the legislature. Your Honors, I think you have all my arguments. Again, our point is that there were different questions presented and there was different evidence presented between the two motions, and therefore the Commonwealth Court did not violate the coordinate jurisdiction rule. I'm happy to take any further questions.
So, counsel, if the appellants would have sued DHS and the Attorney General, then we wouldn't have a problem here.
I'm not sure about that, Your Honor, because I'm not sure the Attorney General would be, if we're going back to proper parties, the proper party to it. Also, you know, the Attorney General doesn't come in every lawsuit involving a criminal prosecution. Our role is somewhat limited, and
so
I haven't done.
Then who would they sue?
Well, it's Ivy Hill's
to get this privilege question answered.
Ivy Hill is based in Philadelphia, and the answer to that is the Philadelphia District Attorney's Office. They're the ones who have a statutory role in prosecuting the failure to report. Maybe I would just want to clarify one thing here. Maybe DHS does not take calls on a mandated reporter's failure to report. They would refer that call to law enforcement. What happens is we get a call of child abuse, and we deal with the allegation of child abuse by referring that to either the Children of Youth and Family and or to law enforcement. They do an investigation. They report back to us and say, yes, it's founded or unfounded, indicated or unindicated, whatever the case may be, and then we take note of that in a central database. But whether during the course of that investigation the police discover some person, some mandated reporter who did not report, that would be up to law enforcement whether to pursue a criminal prosecution. It would not be up to DHS.
And how does that answer the question that the Ivy Hill 1 court perceived in this case, which is, to whom does the privilege apply? I mean, this was a straightforward legal question. I don't know how else to look at it. I mean, you look at the statute, and the appellants raised the issue, does this apply to us? And they looked for an answer. So,
Sure.
Well, you just described to me how enforcement takes place.
Sure.
But how does that answer the question for this appellant, does the privilege apply to me?
It's still in the course of litigation, there has to be adverse interest between the parties. Yes, they have presented a legal question, but the legal question has to be directed to the person who has to oppose it. That's what you've said in these cases. There has to be an interest pressed on one side and opposed on other. And we have no obligation to speak. We have no right to oppose that legal question, whether they're fit within this exemption or not.
Any other questions? All right.
Thank you, Your Honor.
Thank you very much. Want to call the next case, Mr. Minner?
N.W.M and E.M. minors, Langenbach and the Defenders Association of Philadelphia, representing the Defenders Association, letters representing the counties, Mr. Charles Aplt.
In this appeal by allowance, we consider an issue of first impression, whether court-appointed guardians ad litem are entitled to quasi-judicial immunity for acts they perform in connection with their statutory duties. We also consider whether intermediate appellate courts have the authority to resolve issues of first impression which involve policy considerations. The Superior Court answered both of these inquiries in the negative, and we examine the propriety of those holdings. Good morning.
Good morning, Madam Chief Justice, and thank you. May it please the Court. I am here today representing the Defender Association of Philadelphia and its employee, Patrice Langenbach. I'm joined by my brilliant colleague from Obermeyer, Melissa Blanco. And I'd like to begin today just first by saying what a privilege it is for me to appear before this historic court. Thank you for giving me the opportunity. Melissa and I are here to persuade you, hopefully, to reverse the three-way split panel opinion of the Superior Court, which left Pennsylvania as a sole outlier in its, as among federal and state courts across the nation, in refusing to apply quasi-judicial immunity to court-appointed guardians ad litem who serve as best interest attorney advocates for dependent children, and who, in that capacity, are statutorily required to provide to juvenile court judges recommendations regarding how best to provide for the care and well-being of dependent children.
How does that make them akin to the law clerk? I mean, the way that the juvenile dependency courtroom is set up is there's a judge over here, and out there we've got the GAL, we've got the parent advocate, and whoever else we may, the agency, And in trying to convert that GAL into something of an adjunct of the judge, you seem to be bringing them to the other side of the courtroom. That's where the law clerk is. Why are we going to privilege the GAL, who, by the way, under the Juvenile Act, is to represent both the legal and the best interest? Why are we going to privilege them over the parent advocate who's sitting right there in this proceeding?
Well, Your Honor, the Section 6311 of the Juvenile Act does say that the guardian ad litem represents both the legal interests of the dependent child and the best interests of the dependent child. But the obligation with respect to the legal interest is limited. It's limited first by whether the guardian ad litem can ascertain the expressed wishes or the desired outcome of the child. In this case, the child went into dependency at about 7 weeks old, maybe 8 weeks old, and came out of dependency at 2.5 years old. There was never a time in that period when this child could express to its legal interest representative what its desired outcome was.
I think, Mr. Leonard, that's certainly true. And of course, this case is this case, and then there's another case, and some of us on this panel have handled a bunch of these, and there are going to be cases where the GAL is going to rise and say, you know, here's my view of the best interest, Your Honor, but the legal interests are X because this is a 13-year-old, and she says whatever. But the variability of the fact scenarios doesn't change the fact, I think, that you're arguing for an exception to the general rule that lawyers, like others, are accountable for their actions. And we don't tend to view immunity grants, carve-outs, as it were, expansively, but restrictively, right? Because we're removing somebody from the general default, which is that, you know, most of us are liable for our actions. That's why public defenders can be sued, for example. The parent advocate can be sued. You all could be sued, heaven forbid, you know, by your clients. I'm still not understanding why the GAL becomes a quasi-judge in your view.
Well, in this instance, the guardian ad litem was responsible for giving specific recommendations to the juvenile court judge about the best interests of the child.
Counsel.
That's statutorily required.
So, counsel, my understanding is the court appointed the guardian ad litem in this particular case and separated GAL from child's legal counsel, correct?
At different points in the proceeding, Justice Doherty, there was a legal interest representative appointed in the TPR proceeding.
And in fact, in the arena of dependency, the guardian ad litem is almost like a sui generis position, in such that it's unique in the fact that it's an individual who is appointed by the court to give an independent analysis, almost i.e. the eyes and ears of the court, separated from any other contingent issue or legal responsibility to anyone but for the judge. Would you not say?
I would say.
And where else in any other area of the law do we have a court-appointed advocate who is only to give their independent evaluation of the scenario to assist the court, similar to a law clerk, in making its decision?
Well, I think we see that with respect to court-appointed experts, where the judge has some particular issue that it needs help with, independent of what would be developed through the adversarial process as between the experts of the party. They hire an independent expert to advise them on a matter. So I think it's comparable to that. And going back to Justice Weck's question, I think the test for the application of quasi-judicial immunity is twofold. The test is first looking at this from a functional level. What duties is the guardian ad litem required to perform under the statute? And then the courts have described what they're looking for in that context in a couple of different ways. They've talked about whether the person is an agent of the court or whether it's an arm of the court. They've talked about whether the person is integrally related to the judicial process. I submit that when you have someone who is responsible for advising the juvenile court judge about the best interests, and that's exactly the standard that that applies to the independent recommendations that the guardian ad litem is required by statute to apply.
Counsel, can I just follow up on that? Don't court-appointed special advocates do the same thing? Court-appointed special advocates statutorily have very similar duties to gals up to a point. Up to a point. A CASA need only be 21 years old, get some training before their initial appointment, and then they do exactly what you're talking about. They do some of the enumerated responsibilities of CASAs, many of them are exactly the same as the gal, except for those things that only lawyers can do. For example, cross-examination. Meet with the client to determine the thought process, et cetera, to the extent possible. Present argument to the court in court. CASAs can't do that. But CASAs do exactly what you're talking about. They act as the eyes and the ears of the court for the purpose of giving the court recommendations. And here's the rub in this. The legislature created a quasi-judicial immunity for CASAs, but not the kind you're talking about. They are immunized unless there's gross negligence, misconduct, and things of that nature. So you're asking us to do for lawyers what the legislature refused to do for CASA. And I just don't get it. I mean, the essence of what the essence of being a gal that separates you from being a court-appointed special advocate is that you're attorney at law, and you have obligations pursuant to our Code of Judicial Conduct. And I can't grasp this notion that we would grant an immunity to attorneys who are hired to do a job as an attorney in a courtroom. You may want to ask us to extend the same kind of immunity that the legislature extended to CASA advocates in the context of the non-attorney functions that are performed. But I'm just struggling with this notion that we would give attorneys more immunity than a 21-year-old who has 3 months' worth of training before they step into the role of giving advice to the court on their investigation.
Well, Justice Donoghue, I would agree with you. To the extent that there became a conflict, and in this case, in the TPR proceedings, N.M. was appointed with a legal interest attorney. That attorney was strictly responsible to represent the interests of the minor, and the interests of the minor alone, not best interests in a general sense.
Well, that's the interest of the minor.
The interest of the minor.
The best interest is the best interest of the minor, correct?
Well, the ultimate decision, the ultimate standard for the juvenile court judge is best interest. But a legal interest advocate is bound to ask the court not about best interests, but to advocate for the desired outcome or the most desirable outcome if it otherwise can't be ascertained for the child. So it is different. And if you were just a legal interest advocate, I think you can be sued.
Counsel,
If you're the, I'm sorry.
that's okay.
Answer.
Yeah,
Please proceed with your answer.
If you're the best interest advocate, though, you are an arm of the court, an agent of the court. You are integrally related to the process of adjudicating the case. Whatever standard you apply under that first functional test for whether quasi-judicial immunity applies, the guardian ad litem under 6311 qualifies. The next aspect of the test is whether in the performance of that function, those duties that qualify the person as a quasi-judicial officer, whether the person requires freedom from fear and intimidation and harassment in the proceeding. And here, when we're talking about a situation where there is the government on the one hand, who based on a report of abuse or neglect, most often, goes in and takes a child from a home on the one side. And on the other side, parents who fiercely deny the allegations of abuse and neglect and fiercely fight to get their child back. In the middle is this guardian appointed with the sole job of representing the interests of that child, that minor child. And if between those forces, that guardian ad litem is fearful of harassment by subsequent lawsuits, then the independence of that guardian ad litem is compromised. And that compromised position ripples through the justice process, because then, as Justice Doherty was saying, the juvenile court judge is not receiving those unbiased, those independent recommendations that it requires in order to judge the case based on the best interests.
Unless a CASA was reported, unless a CASA was appointed, because one of the responsibilities of the CASA, who has no overall blanket immunity in these contexts, must submit a written report to the court to assist the court in determining the disposition best suited to the health, safety, and welfare of the child. It's a non-attorney doing that function for the court.
Well, the Juvenile Act, Justice Donoghue, doesn't address one way or another the question of immunity under 6311.
But let me ask the question. 6342 permits CASA immunity except for those gross negligence, intentional misconduct, or recklessness. The question I have for you, are you seeking the same, or are you seeking additional immunity?
I'm not sure I know off the top of my head what
6342 reads. It's court-appointed special advocates, as Justice Donoghue said, CASA. Immunity. A court-appointed special advocate shall be immune from civil liability for actions taken in good faith to carry out the duties of the CASA under this chapter, except for gross negligence, intentional misconduct, or recklessness, willful or wanton misconduct.
So that is an articulation of a qualified immunity standard. And I am here today arguing in favor of absolute immunity.
Okay.
Yes.
Well, yeah,
I would say,
counsel, it's an example of statutory immunity too, which is different from quasi-judicial immunity, which is non-statutory. You know, we have district attorneys, for example, are supposedly representing the public, and the statute gives them, they have statutory immunity, not quasi-judicial immunity. Nobody would ever argue that they're an arm of, I would hope that no one would argue that they're an arm of a court. My problem is kind of more basic, and I kind of want to go back to the line that Justice Wecht was asking you about. This is I could probably swallow pretty strongly the idea of granting immunity to someone that I appoint simply to give me advice. That would not be a hard thing for me to do. But the GALs, as I understand it, which are a creature of statute, not a creature of our creation, a creature of statute, are specifically empowered and do advocate for an interest. Now, it may be this, and I'm going to ask Mr. Becker this line of questioning, but it may be an interest that is not suable. It may be that there's a client that could not bring a malpractice action because the client is the best interest of the child. But where do you get this arm of the court thing? Simply because the court appoints? Every lawyer who appears in front of us, all the lawyers that have appeared in front of us this week, are giving us advice. They're giving us advice on the law, and they're advocating their position on the law. How is a GAL any different?
It's very different, Justice Brabson. It's different in the sense that every one of those other lawyers that came before you was representing a party, and that party had a desired outcome. And the lawyer...
And the GAL doesn't have a desired outcome?
The GAL's duty under the statute is to represent the best interests of the child.
Which is the client.
And the legal interest.
Yeah.
Well, the legal interests up to a point.
But they're advocating...
By statute and the rule.
Yeah, but counsel...
So when there's a conflict...
Counsel, excuse me.
Yes, sir.
But they're advocating for the best interest of the child. I am assuming that the parents, although they have an interest as parents, are also advocating for what they believe to be the best interest of the child. Everybody's because the standard is the best interest of the child. Everybody's advocating to the court as to what the best interest of the child is. The GAL, as I understand it, is being appointed to represent the best interest of the child, which is different, but doesn't make them any less of a courtroom advocate.
It makes them an advisor to the court.
Well, then we shouldn't bring it. We should bring them to the other side of the bench, like we would have clerks and experts and things like that. But when we put them on that side, and the parties have to argue against them, or we should put them on the witness stand. I don't know, but I'm really struggling with this because I think what they do is incredibly important, and the General Assembly says what they do is very important. And my colleagues on the bench who have experience with GALs know that they are very important, and I want to be helpful. It's the advocacy aspect of it that I'm struggling with.
Well, maybe it's because the dependency court proceedings are not traditional court proceedings where a lawyer is coming in representing a desired outcome for its client. And yes, it has to think about what the standard is, but it's arguing for the desired outcome of its client within that standard.
Follow up on that, Mr. I know you're not suggesting that these aren't hearings. In other words, as you know, the dependency hearing is a hearing. It operates with regularity. Witnesses are sworn. Advocacy is provided. It's not a conversation. It's not an informal consultation. The proceeding operates with the gal would be over there where you are and making argument and calling witnesses to the court. The parent advocate would be doing the same, and the county solicitor, or whoever's representing the agency, the same. Nobody's suggesting the gal is not extremely important with her duties under 6311 for legal and best interest. But the question that I have is, isn't your argument best directed toward the General Assembly to try to convince them why the GAL should be privileged over the parent advocate, who, just like the GAL, is appointed on these, group in the large jurisdictions. The large organizations get these appointments from the court, and then they staff these out as is appropriate. Why the privilege should come to the GAL that the General Assembly provided to the CASA and didn't provide to the GAL, the parent advocate, the county solicitor, the public defender, who also has an important public rollover in those cases.
Justice Weck, I've sort of lost the question there now, again.
Bottom line, isn't the argument to the General Assembly, look, senators and representatives, these are really important folks. They're providing a critical role. We want you to treat them for immunity purposes like the CASAs.
Well, we're talking about a statute that's already in effect, and we're talking about court law, case-made law, that talks about when quasi-judicial immunity is applied. The statute that we have here doesn't speak at all to the question of whether a guardian ad litem under 6311 is entitled to immunity. But very importantly, there is nothing in the Juvenile Act, in the text of it, or in the legislative history of it, that suggests hostility by the Pennsylvania General Assembly towards the application of common law principles of immunity, like the doctrine of quasi-judicial immunity. And the case law in Pennsylvania suggests the test for that is the one I articulated a few minutes ago. Is it a function that is an agent or arm or integrally related to the judicial process? I submit it is. It's helping the judge make a decision. And second, does the guardian require, in performing those duties, freedom from fear and intimidation? If you meet both of those tests, then the law in Pennsylvania suggests that you get quasi-judicial immunity.
Counsel,
Doctor, you had a question.
Counsel, I guess the concern that I have is my colleagues are indicating we should run to the General Assembly. My understanding of your argument is that you're asking this court the specific legal question as to whether our reading of those statutes and rules that exist with regard to guardian ad litem, specifically making the court appointing at a GAL for the sole and specific purpose of not giving a myopic piece of advice as regard to a parent's attorney, aka give me my kids back, or a solicitor's position, aka DHS or children and youth are correct. This is a position to advise a panoramic view of the best interest of the child to the court and to the court only. And you're asking us, because the statutes are silent despite the sole responsibility of the guardian ad litem to be the eyes and ears of that juvenile judge, that they should in fact enjoy the qualified immunity. Similar that if I, as a juvenile judge, accepted the recommendation and placed an order with my signature, I could not be held accountable based upon my acceptance and my empowerment of the recommendation. But we're now saying guardian ad litems may now be held liable for giving me the advice which I accept. Am I following your argument correctly?
That's it, Justice Doherty.
Okay.
Yes.
And then supplemental to that is the I lost the train of thought there.
Well, I can, if I could, I might put his train back on the track, so I'm going to go. I can embrace everything that Justice Doherty is saying. My problem is really where that happens. If the statute, even if in practice, let's say it happened in practice, regardless of what the statute says, because I don't think the statute really does say anything about, well, maybe it does, about actually standing on that side. But if the statute empowered me as the judge to have a guardian ad litem, and that person was with me back in chambers when I was deliberating, and based on the arguments of the party and the evidence that was heard, that guardian ad litem said, Justice Brobson or Judge Brobson, we've listened to everything. We advise you that you should rule this way in the best interest of the child. I could embrace the idea of quasi-judicial immunity pretty easily. So I'm trying to understand, and I'm not sure you're going to be able to give me the comfort I need of this advocacy point, this standing there in court and being a lawyer, just like a public defender who we appoint, who, you know, and I understand that they're representing the defendant, but they're also advising the court on how to proceed. It's that's happening. If the guardian ad litem was simply behind me or back in conference and saying, Judge, this is what we believe to be in the best interest of the child, this would be a completely different case.
But that's exactly what it is, except they stand on the other side of the bench with the panoramic view of listening to the arguments and the positions of the various parties. The problem, as in this case, is that many times it's perceived as the guardian ad litems join forces with the particular side, a.k.a. the city solicitor or parent's attorney, and lends the impression that they're advocating. They're advocating solely for the court. Similar to Justice Brobson's recommendation, when the court appoints a public defender, it's to protect the rights of that individual.
Right.
When I, as a judge, appoint a guardian ad litem, I'm appointing that attorney to provide me and solely me what I am to perceive as their independent, specific recommendation pursuant to statute and procedural rule. And that's a huge difference than my appointment of a public defender to represent the fundamental liberty interest of a defendant. Huge difference, which is sui generis to the arena of dependency, because we have no other arena of the law. Even our guardians in orphans court, it's to protect that individual, not to protect the court. That's the difference.
Well,
Your
but
Honor,
isn't I'm sorry, go ahead and answer.
Justice Doherty, the only thing that I would add to that is that the dependency proceedings themselves, I agree completely that the guardian ad litem is making recommendations to the court, but it's doing that in the form of advocacy, because in the proceedings, the courts, the juvenile court judges, then get the benefit of having the other parties cross-examine and challenge. The judge
GAL does that. The GAL does conduct direct and cross-examinations.
The GAL can.
Yeah.
But it's a specific mandate pursuant to 6311B7 that they make specific recommendations to the court.
Precisely.
And so they're following a statutory obligation and mandate not to advise or give their perspective as to the interest of the party before the court, but to give a specific recommendation, because I'm anticipating Mr. Becker to share with me how I misunderstand the statutory mandate.
I agree. I mean, I do think that they present witnesses. I do think that they talk about evidence. I do think, though, Justice Weck, respectfully, that the proceedings in independency courts are less formal than traditional legal proceedings. Yes, there are witnesses. Yes, there are evidence, but they are not bound by strict rules of civil procedure.
Well, I've presided over a few thousand of them, and I can assure you that there's a record and the witnesses are sworn, that the GAL makes argument, calls witnesses, and advocates, and that there are no ex parte communications between me as the dependency judge and her, that she's over there with the parent advocate and the county solicitor, and she or he does their zealous job of providing the legal and best interest pursuant to 6311, and then I go back and make a decision, or I make it in open court, and if I want advice, immune advice from my law clerk, that's fine, but I don't go back with the GAL and treat him or her as a quasi-judicial official. That's a lawyer who is lawyering a case, just like the parent advocate and the county solicitor are lawyering the case.
Respectfully, Justice Weck, I disagree. They're lawyering to the extent that they are performing their statutory duty to provide the court with specific recommendations specific recommendations under the standard the court needs to apply to adjudicate the thing, to the dependency court issues. And they have to they have to do that by looking at the global picture.
Right, but no one disputes the critical importance of the GAL. That's a given. There's no dispute there. The question is, is there something about their role that brings them over the bar and puts them with us?
I think if you look at the case law in Pennsylvania, the case law in Pennsylvania suggests this two-step process that I've suggested here today. Are they an agent of the court? I think they are. I think to the extent that they're the only one who is empowered by statute to go out and study, to interview witnesses, to collect information, to collect things as private as the mental health records of mom and dad who are accused of abuse. To the extent that they are given that power to conduct an investigation, and then based on that based on that investigation, make recommendations to the court about the best interest, needs, welfare of this child, they are specifically within the agency, the arm of the court, the integrally related, whatever that standard, however it's articulated, they're in it. They're doing a court-related function, and in the context of a statute that doesn't address whether they get.
Counsel, if I may follow up on this. You resorted to articulating the investigative function of GALs and the crucial role that plays in going into their recommendation to the court. I urge you to review the duties and responsibilities of CASA because they have access to all of those same records you're talking about, et cetera, et cetera. So, I mean, my focus here really is on what GALs do as attorneys at law, what they do as officers of the court. And you're not suggesting that when an attorney conducts cross-examination or articulates an argument to the court or picks a strategy to follow during the trial, that attorney who is a GAL is not bound by the rules of professional conduct to perform all of those duties with competency and to follow all of the other rules of judicial conduct, correct?
Absolutely.
So what are you asking us to do then? Immunize them from not following the rules of professional conduct?
No. I mean, they have to follow the rules of professional conduct, certainly.
Without any potential civil consequences for malpractice, as other attorneys would be under similar circumstances.
Correct.
Conducting cross-examination.
And that's because, Justice Donahue, if they are fearful of being harassed with a case in the future, a damages case, it undermines their independence, and then it undermines the courts.
Isn't that true of every attorney who should be fearful of potential malpractice cases if they don't perform the duties pursuant to the standards of the rules of professional conduct?
The difference is that those other attorneys are representing the stated interests of their client, and they are articulating findings and conclusions that relate to the interests of their client, not the best interest standards that applies that the juvenile court judge applies in deciding the issues in juvenile court cases.
Why is that a lesser responsibility? To me,
it's
a
not
higher
a lesser
responsibility,
Justice Donahue. It's a very sacred responsibility. My point is that if there's fear of a lawsuit down the road, that compromises the independence of the guardian ad litem. It compromises their ability to advise the court as they're required to do under the statute, and it compromises then the judge's ability to decide the case in the
Mr.
best
Leonard,
interest of the child.
I know the GAL represents the best interests of the child. In your view, does the GAL represent the child?
I think the statute says that the GAL is both the legal interest and the best interest representative of the child.
Unless there's a conflict.
Unless, well, of course, unless there's a conflict, and then the guardian ad litem, a legal interest counselor is appointed, and at that point, the sole responsibility of that attorney is to the client, and they can be sued. The best interest attorney is different. Their role.
Is there any reason to try to think through your chilling effect argument or your harassment argument? Is there any reason to expect that GALs would feel chilled or intimidated, or so? It's inconsistent with my experience with GALs. I've never met a shrinking violet. I don't expect that we would see people seeking appointments as GALs who face the matter with timidity, any more than any lawyer now who, under the rules of professional conduct, has a duty of zealous advocacy. You seem to be suggesting that there are scenarios out there where something in the course of the GAL's engagement would be deemed by, I suppose, by some guardian of this dependent child at some later point to have been a defalcation or prejudicial or some actionable, and that then some lawsuit would ensue. And can you sort of walk through how you see that, such a thing developing in real life?
Well, it happened in this case. There's a lawsuit now being filed against the guardian ad litem, the only person in this process that isn't protected by some sort of immunity. The judge is protected. Children's Hospital, which made the report of abuse and neglect, or the report of it, is immune to some extent. The city solicitor is immune. The Department of Human Services is immune. And what happened here is that these parents, after the fact, decided that the only one standing was the guardian ad litem, and let's sue them.
Is this the exception that proves the rule? In other words, is the GAL's conduct here the opposite of timidity, the opposite of showing any fear of harassment or of being subjected to the perils of litigation exposure, of liability?
Justice Weck, I can only refer you to the amici brief that was filed by Kids Voice and approximately 24 other county representatives who were, or GALs who serve as GALs in 24 counties. I think that was the correct number. That brief says that these GALs, who are among the lowest paid attorneys in the Commonwealth, by the way, and who take on this really noble task of going into court between these two powerful forces and risking their necks to represent children, they need protection. And if they're going to get sued down the road, and even, frankly, Justice Donahue, if it's a qualified immunity, so that they're going to get sued and they're going to get, then there's going to be a fight as to whether they acted recklessly or negligently. And so they're already exposed now, again, to a fight, a costly fight.
Well, under either circumstance, a certificate of merit has to be filed with the filing of a malpractice case like this.
Well,
so, it's not exactly a parent's view. It's a view that's been vetted by someone with the qualifications to determine whether or not they fell below a standard of care. I mean, that's what malpractice cases are. I mean,
no, they're subject to an allegation of recklessness in that case.
Accompanied by, as they must be under our rules of procedure, a certificate of merit when a professional malpractice case is filed. So, I mean, it's not as though this is open game for anyone to just willy-nilly decide, I'm going to sue these people. There's a process that the plaintiff has to go through before proceeding to court.
And a guardian ad litem, in its job of representing the best interests of the child, is required to make tough choices, really tough choices, and take tough positions. Sometimes it's the parents that are angry about it. Sometimes it's the government authority that's angry about it. But they make these tough choices in making recommendations to the court. And if they're at risk that someone down the road is going to sign a certificate of merit and put them through 3 years of litigation as to whether they're negligent, if there's no immunity at all, or even if there's qualified immunity, they still have to go through that expense and to determine whether they were just negligent or reckless. That alone, that fear, can compromise the process and compromise the entire judicial proceeding.
They're required to have liability malpractice insurance, right?
There is malpractice insurance at the Defender Association. I can tell you that as a result of these cases, there's a question about whether the Defender Association can afford to keep doing this work.
Mr. Leonard, could I follow up? You mentioned a moment ago about the, I think anger, I'm not sure if you used the word anger, but the volatility to which the GAL could be exposed, and that's clearly correct. Do we have any reason to expect that parent advocates could not be exposed to at least as much volatility on behalf of disappointed clients, as it were, or the same public defenders? So if we grant your relief, should we, in the same order, declare that along with GALs, all parent advocates and all public defenders in the Commonwealth of Pennsylvania also are categorically immune from malpractice lawsuits?
No.
What's logical, because a parent advocate only advocates for the parent, and if someone's going to be angry, it's the parent, as opposed to a guardian ad litem who may have a position whose recommendation to the court specifically will anger both child, a parent, city solicitor, and all the above, which often results in violence in the courthouse. And I can attest to that as my own personal experience. Maybe this scenario is different than other
Can
scenarios.
you answer your question, Justice Weck?
No. You could probably perceive that Justice Dougherty and I, notwithstanding our similar experiences, have different perspectives, and that's fine.
Well, I think I would have given about the same answer.
I'm sorry?
I think I would have given about the same answer to the question as Justice Dougherty did. So I wasn't trying to duck the question.
All right, could we see if there are any other questions from the court? If not, would you like to sum up, Mr. Lemon?
I would. Thank you. So I think at the end of the day, in a situation where a statute is silent and it says nothing that suggests hostility by the General Assembly to the application of traditional standards, common law standards of judicial and quasi-judicial immunity, that the test is twofold. Is the person acting as an agent of the court? And if so, and I believe that to be the case, beyond question here with respect to a guardian ad litem under 6311, does that person need to be protected from fear and intimidation? And I submit again that that is definitely the case. If you satisfy both of those tests, you're entitled to immunity. I think guardians ad litem appointed under Section 6311 satisfy those tests. And I don't think any of the arguments made by the other side about the difference of the guardian ad litem, the guardian ad litem is just an attorney, or that you need a damages remedy in order to keep the guardian ad litem on its toes. I don't think that that's valid. In fact, with respect to that last part, there are many safeguards in the system that protect a guardian ad litem. One is that the guardian ad litem is subject to the supervision of the court and can be replaced by the court if it's not doing its job. And if parents are dissatisfied with the performance of a guardian ad litem, they can petition the court for removal of the guardian ad litem. And there are also fast-track appeals that allow any error in the process of decision-making in dependency courts to be taken up to the appellate, the intermediate appellate court, and corrected immediately.
And there are also disciplinary referrals, right?
Correct.
Okay.
All of those things act to present adequate safeguards. And the risk, on the other hand, the risk of being sued undermines and creates more harm than good by undermining the independence and then ultimately the decision-making of the juvenile court judge.
Thank you, Mr. Leonard. Let's hear from Mr. Becker.
May it please the court, I'm Chip Becker, here with my colleagues Andra Leidacher and A.J. Thompson. Collectively, we represent the plaintiff in this matter. The Defender Association says or asks the court to rule that when a person is appointed as a guardian ad litem, they are endowed, they are entitled to absolute immunity flowing from the doctrine of judicial or quasi-judicial immunity for any acts connected to that appointment. This request to be enveloped in judicial robes for purposes of potential tort liability is a big ask. And to be clear, it is their ask. The state of the law in Pennsylvania today, with respect to the doctrine of judicial immunity, is that it is confined, if the case law is any measure, it is confined to the folks who work on your side of the room. Obviously, the judges and the justices, your law clerks, prothonotary, court administrators, special masters who the court appoints for the as their eyes and ears. Becker, I'm sending you out there. I want you to investigate, report, and recommend to me, right? People on your side of the courtroom are judicially immune. The request here is to extend the doctrine of judicial immunity so that it applies to people on my side of the courtroom. And if I can just say that if I were to do a poll of everybody sitting in this courtroom, I think everybody has a very clear understanding of who is a judge and who's a lawyer. And I'm definitely not a judge standing at this lectern. And that is the lectern where Patrice Langenbach and everyone at the Defender Association or anyone who is a guardian ad litem and also a child advocate, which is the facts and circumstances of this case, stands when they present argument, render objections, and conduct themselves in a courtroom.
Mr. Becker, would you agree that the guardian ad litem is a hybrid position representing both the court pursuant to its statutory and rule mandate as well as the child in the best interest? Or do you disagree with that?
Well, since you're asking, and you probably know, I think it's safe to say that you know a lot more about this than I do. I am loath to say that you're wrong, right? I don't know what a hybrid, exactly what it means for the GAL to be a hybrid. Well, so clearly what the GAL does is by statute is to speak for the best interest of the child. How we characterize that, I'm not 100% sure.
Share with me any other area of the law in which an attorney is appointed to advise the court singularly and only based upon that person's observation of a dependent proceeding with the overarching concern of best interest.
Well, a judge could appoint a person, a lawyer, and denominate that person as a guardian ad litem, and to the scenario that I described just a moment ago, and repose in that person a charge. Go out and be my eyes and ears, write up a recommendation, report to me, and tell me what you think. That is something that can happen within the context of what we denominate as the guardian ad litem. But in the context of this case, if I can sort of step back from public policy moment about guardians ad litem and actually locate our discussion in the facts and circumstances of this case, and Justice Doherty, I think this is maybe by way of trying to engage with you on some of the observations that you made with my brother counsel. The claims in this lawsuit involve an attorney who operated in two different landscapes. One, there was an appointment as guardian ad litem for the best interests of the child, whoever that client is exactly, and wherever that responsibility runs exactly. But there was also a parallel appointment of equal dignity, to be the lawyer for the child. This lawsuit is not premised, this complaint that's in this record is not premised on a violation on the breach of duty of Patrice Langenbach in her role as guardian ad litem. It is premised on the alleged breaches of duty of Patrice Langenbach and her employer, the Defender Association, in their role as the lawyer for the child. I understand that she's a guardian ad litem. I understand, we all understand in this room, and especially those of you who have been administrative judges of family courts, how important the role of the guardian ad litem is. But this case, and if I can urge you to think, I'm not going to urge you to think, but if I can...
Try to always.
Right, exactly. Right, exactly. We'll preserve judgment, right? If I can urge you to take this as a common law court, right, and to locate your analysis in the facts and circumstances that are in front of you, then where we are is a negligence claim that's been asserted by a minor, an 8-year-old girl, against her lawyer, not as guardian ad litem, but against her lawyer. And that dual appointment.
I have to take issue with that. That's not the issue we granted. Question number one, whether quasi-judicial immunity applies to a guardian ad litem. That's the issue before the court, not this negligence actions from a minor against an attorney or legal malpractice. It's this court making a determination whether a guardian ad litem position, a court-appointed position, enjoys quasi-judicial immunity.
Well, that is the question as the Defender Association would posture it, but that is not the path, or that question does not decide the outcome of this case. Because even if this court should decide that a person denominated as a guardian ad litem, by virtue of that appointment, is entitled to categorical, status-based, absolute immunity, which, by the way, is something that basically doesn't exist in Pennsylvania law. It's been systematically removed by this court over a period of decades, leaving a very small reservoir of such immunity. And that reservoir really revolves around what we do in this courtroom, right? Judicial immunity, quasi-judicial immunity, prosecutorial immunity, witness immunity. There's a series of interrelated immunity doctrines, which are all that is left, all that you have left in Pennsylvania law with respect to common law status-based immunities.
Mr. Becker, can I just interrupt you for a second? I'm willing to go down this path with you a little bit on the dual role of guardian ad litems. I may even know less than you know about this, but I promise you I will do my best. The issue about quasi-judicial immunity, I think, may have value in terms of that advisory aspect to the court. I'm wondering if this issue is less about immunity and more about what you're essentially saying is identifying the duty in this particular challenge. So I think it's interesting that you have divided that line between the GAL representing the child versus representing the best interest of the child, because that's how I see the case.
And that, by the way, is how the orders read.
And so maybe GALs don't have quasi-judicial immunity, at least when they're serving this advocacy role in court. But maybe the only plaintiff that could ever sue a guardian ad litem that advocates for the best interest of the child is the court. Because the duty, that duty, is to the court, as Justice Doherty so eloquently stated. That duty to render advice, that duty is to the judge. And in any negligence action, you need a duty owed, right? Can you explain to me why you're saying your action in this case does not go toward the GAL's conduct advocating for the best interest of the child to the judge, the duty to the judge, and goes more to the actual duty to the child's legal interest?
Well, to the point that was made earlier, you have a very young child, and it's not like you have a scenario where you have a 13-year-old or 15-year-old who says, I want to be with mom or I want to be with dad, and then her court-appointed lawyer argues for the opposite position, right? So we don't have a record that's as clean as all that.
Well, you actually said it was that clean. You said it was. You said
well,
this case is not about the
conceptually, but there's not record evidence that would sort of highlight that in as clean a term in the cleanest terms that we might like. But this case is postured as a child against her lawyer. And yes, her lawyer has an obligation to, under the statute, to advocate for her best interests, but also has an obligation, for example, to investigate the facts and circumstances of her case, has an obligation to explore and talk with the witnesses.
But I guess it goes to my duty. So who's that statutory duty owed to?
100% to the child. As the legal advocate of the child's interest, that is, she is functioning as a lawyer, representing a child. And
I know it's not the question here. I'm just trying to conceptualize, okay, so what happens if we say there is no quasi-judicial immunity, which I agree with you is either you have it or you don't have it. There's no sort of halfway. I'm wondering, though, whether in this advisory role, subject to a preliminary objection, I would assume, can even maintain a malpractice action where the guardian ad litem is acting solely in the function of advising the court in the best interest of the child.
Well, I think, Justice Brobson, to the scenario that you were describing earlier, if we have a scenario, and Justice Doherty, I'm going to say to you that this scenario is not what happened in this case. If we have a scenario where someone is denominated as a guardian ad litem, and they're told, Becker, I want you to go out. You're working for me. I want you to go out. I want you to find out what's going on. I want you to give me a report, make recommendations to me, right? That is a scenario where I don't think anyone would be surprised if the court were to looking at role and function. And I think role and function, or if I can speak more colloquially, what actually happened, right, is a more useful framing than duty, if I may. But I think if that's what actually happened, that's a fact. And looking at this from a common law perspective, that's a scenario that I think, first of all, it looks like other cases. There's a series of cases where you have court-appointed guardians ad litem who have been directed to investigate, report, advise back to the judge, truly as an agent of the judge, and who have and to whom judicial immunity or quasi-judicial immunity, however you want to think about those documents, doctrines, has been extended, as opposed to what happened here, where you have a lawyer who has two different capacities: the personal lawyer for the child, also a separate duty to act for the best interest of the child, who functions as essentially a free radical in the courtroom, an independent person in the courtroom, not reporting to you. Not reporting to you. She's not going back, she's not testifying to you. She doesn't write a report to you. There's nothing that happened in this case that was in the character of someone who had been appointed to function as a special master or something like a special master. Or a CASA. There's no indicia of that in this case. Everything that is described in this complaint is in the nature of a lawyer practicing law, making arguments, making evidentiary objections. There's nothing more lawyerly than actually standing up and objecting 37 times to the introduction of evidence. There was also no allegation in this complaint that the guardian ad litem ever made a recommendation to the court, ever made a suggestion to the court, did anything on behalf of the court, investigated anything for the court, reported to the court. Now, I understand the idea that, well, it sort of happens in a gestalt kind of way, and it looks like advocacy, but really, I mean, that's Mr. Leonard's argument. It sort of looks like advocacy, but really, it's actually something much more. It's actually, although it looks like a lawyer arguing across the bar to a judge, actually, they're on the same team, and I think that as a matter of practicality, if it looks like a duck and quacks like a duck, it's a duck.
Well, let me just tease that. So, based upon your comments here, the defender's conduct is exclusively that of legal counsel.
Well, not exclusively, but there are two independent roles of equal dignity, and our lawsuit proceeds down one path and doesn't proceed down the other.
So in May of 2018, when Judge Young recused herself and removed the defender as legal counsel and only made the individual as guardian ad litem, does that mitigate potential damages from the inception of the case in 2016 to May of 2018? Because it seems what you're arguing that if this case were to say that the defender's responsible, the period of responsibility is from the inception of the case in 2016 until May of 2018 when she's removed as legal counsel. And I'm gathering that that's what you just argued. Is that what you mean?
So the case, when Judge Tereshko, you said Judge Young removed her. I think you meant Judge Tereshko.
I believe Judge Tereshko removed her as guardian ad litem. Judge Young, Judge Young, Lyrish Young, removed her in May of 2018.
2017. I'm sorry, not to get into the, or correct you or get into the facts, but.
Right, okay, that's even more. So it would be 2016 to 2017, the period that she was acting as child advocate as well as guardian ad litem. Once she's appointed and made guardian ad litem, that no longer is part of the damage that you're alleging based upon your argument. I'm just trying to see where your argument flows.
No, I appreciate that. Let me just say, as a matter of the record, looking at the docket, it doesn't. I actually don't see an order on the family court docket where the Defender Association was removed as child advocate. It appears.
At the goal change petition, the filing of goal change, my understanding from the record, May 2017, DHS moved to change to goal determination of parental rights, and Judge Young granted the goal change, removed Langenbach as child advocate, but allowed her to remain as guardian ad litem.
Yeah, I think that's right. I'm just wanted to reflect that on the family court docket. There's not really an entry, but I'm not really quarreling with that piece of the evidence.
Because otherwise, I'm just trying to follow your theory.
Right. So,
what your argument so far was that if, in fact, they were to do, as you say, investigate and report, which is statutorily mandated as well as rule-based, you're saying they would not be accountable, but because they're advocates, they would. So that would only be from 2015 to 2016 to 2017. Based upon
and that's where the thrust of the conduct, the complaint, the major thrust of the complaint has to do with activities that happened during that period of time. I don't want to stand here and frankly concede that that the parameters of this lawsuit are fit only within the period of the initial appointment to the period of the when the Defender Association was removed as the child advocate. And I am not going to concede that guardians ad litem are not capable of being held accountable for their actions, and that you should expand the doctrine of judicial immunity, your common law doctrine of judicial immunity, to cover guardians ad litem as a categorical status-based matter. But I will agree with you, Justice Doherty, that the theme of this lawsuit is directed to Patrice Langenbach's role as the child advocate, although it is also true that the complaint talks about her work in the best interests. So the complaint itself embeds the ambiguities that I think all of us are thinking about, between where you have an enmeshed, where you have one person who embodies two different concepts, legal counsel and guardian ad litem. Where I think I want to sort of extend our conversation is that the posture of this appeal is that you have a common law doctrine, which is a remaining reservoir of common law immunity, which has, as a practical matter, been confined to circumstances involving you and the folks who work directly for you, law clerks, prothonotary, court administrators, special masters who are court appointed with very direct guidance and advice. And the request now is to expand that doctrine in a categorical way. It's not just, we're not just applying a doctrine to new facts. They are asking you to significantly expand the scope of that doctrine, to take it across the bench to the folks who do what I'm doing now in circumstances where it is manifestly clear that what the lawyer was doing in that case, what Ms. Langenbach was doing in that case, by any conceivable imagination, well, sure looked like being a lawyer, right? Lawyers who have accountability, lawyers who have malpractice insurance, lawyers who have duties, both legal and professional. And if there is an argument that immunity should be extended to those people, because that is the request. I want to just have a side note that in the 340-year history of the Pennsylvania courts, there has not been a runaway train of lawsuits against people who have been denominated as guardians ad litem. We're not really having a medical malpractice moment in Pennsylvania where all the doctors are going to leave if they're not immune. That is just simply not the conversation that we're having. But what I want to press on you, Justice Doherty, is that the thoughts that you have offered, of which I am deeply respectful, and I think everyone in this room is deeply respectful, are properly, I will submit to you, are better addressed to the legislature as part of its policy making, and your court has talked about that in Tincture and Scampone a number of times. Your court has talked about the idea that the branch of government that is best suited to balance competing policies and make these kinds of judgments is the legislature. The question now is, should your concerns be enacted and operationalized through an expansion of the common law doctrine of judicial immunity under the facts and circumstances of this case, mindful of the function that this lawyer was playing? And I would respectfully submit to you that deeply respectful I am of your concern that this court and this method is not the way to do that.
Why, let me ask you, why should this not be a logical extension of judicially made or judicially created doctrine similar to prosecutorial immunity? They are absolutely immune from their advocacy in the courtroom because they have a hybrid. They are there to represent the victim, but the overarching goal is to represent the Commonwealth. The guardian ad litem, as very analogously, is there to represent the child's best interest as best perceived, yet the overarching goal is to represent what is the best interest for the judge and the judge only. So I understand the reservoir, but we have room for additional elements.
Right.
Tell me why this reservoir is so high that it cannot accept immunity for a guardian ad litem analogous to a prosecutor.
So if my mother were here,
Your mother is here.
And my mother is here.
I want to recognize that we have counsel's mother, a former master of the Philadelphia Family Court, proud, and you're in a wonderful state to say your mother could be here.
Yes, indeed, indeed. My mother would say.
Welcome, Mrs. Becker.
My mother would say it's your back.
That was a good card to play too, Mr. Becker.
Thank you, thank you.
Mr. Leonard, in all due respect, is your mother here?
So if my mother were here, she would say, it's your bag of marbles, okay? And it's your bag of marbles, right? It's your doctrine. I'm not going to tell you that you can't. I mean, I just wouldn't. I mean, I'm not going to, and it wouldn't be right for me to say that you can't expand this doctrine in the way that has been proposed. What I can suggest to you is that your cases have been very clear across several decades that these kinds of sort of richly textured policy questions are well suited for legislative assessment and determination. And Justice Donahue, to the point you were making earlier, the legislature has done that on multiple occasions. It's done that in CASA. It's frankly done that in the Child Protective Services Law.
Categorically at the causes and made that judgment, and the judgment's been made categorically with assistant DAs. But paradigmatically,
I'm sorry for interrupting you. Go on. I just want to finish. I'm sorry, Justice Wecht. I just wanted to finish this thought, Justice Dougherty, and say that prosecutors have been described in the case law as performing a quintessentially public function. And the case law that endows prosecutors with prosecutorial immunity has been contrasted with other cases that say that public defenders representing a person in a criminal setting is serving a private interest, even though there might be a federal or state interest in the work of public defenders, even though they might be funded by virtue of statutory authorization, still the interest that they serve is a private interest. So you have the public interest, the purely public interest that's served by the prosecutor, the private interest that is served by the public defender, and that's how the case law breaks in terms of whether an immunity doctrine applies or not.
In a criminal case, not
in a criminal case. In a criminal case, right. And I think all of us understand that what we're looking at here is muddy, right? Because you have a person who has a sort of quasi-public function of acting in the best interests of the child for the benefit of the court and the community beyond, but also has, and that is the fact of the matter here, but also has a private function of being the legal counsel to a child, and then sort of lay on top of that what actually happened in this case was I mean, not to be simplistic about it, but it sure looked like a lawyer who was doing lawyer things. And what I will suggest to you then is that as between these competing principles, and let's call them competing principles, there's different points of view. That's why we're here, right, is because there's different points of view. That from the prism of thinking about how you should apply your common law doctrine, that if there is a tie, and there isn't on these facts and under these circumstances, but if it's a push between these appointments of equal dignity,
we do have 6 justices, so there may well be a tie.
Okay. Well, accountability. The tie goes to accountability. The tie goes to accountability, and the reason it goes to accountability is because of deeply ingrained doctrines that are part of Pennsylvania law. It is a deeply ingrained doctrine of Pennsylvania law that people are responsible for their actions. People are capable of being held liable for the things that they do. Lawyers, among them.
And Her Honor was not held other than a suspension from the Court of Judicial Discipline, because it's the result of the signature of the judge that caused this travesty, not the recommendation statutorily mandated by the guardian ad litem.
I'm going to suggest that the defendants hire you as a causation expert, right? And you can testify as to intervening causation, which might vitiate the case.
I think you may have. Again, maybe I'm fast forwarding the case. I'm skeptical of how far you're going to get in this litigation, just because you are going to have a causation issue, you are going to have a duty issue, and it's going to be interesting to see if we get past immunity, how this rolls out.
Right. Right. So I'm not. I am here. I am here to say that I am in. Maybe this case will be lost, but we are entitled to not have it lost on grounds of immunity. I am entitled to lose this case on some other ground than that a lawyer performing lawyer work is absolutely immune. And what I want to say is that not only is it a deeply ingrained principle of Pennsylvania law that people are accountable, are potentially liable for the things that they do, and that's not me, that's you who have said that multiple times. That's a deeply ingrained basic principle of Pennsylvania law. But let me add that that principle flows from something that's even older. It's 340 years old. It's the principle that a person has a remedy for wrongs done to their person and property. It's a 900-year-old principle that William Penn brought to these shores and has been part of our Constitution ever since. When you consider the principle of remedy, the constitutional commitment of the people of Pennsylvania to a remedy, and then you consider the complementary principle established repeatedly and reaffirmed repeatedly by this court, that people are responsible for their conduct. What you have is a texture, a framework, Justice Doherty, which I would suggest does not support expanding your common law immunities in this setting. It may justify your testifying in Harrisburg for why the General Assembly should do something, but it doesn't justify expanding the common law immunity here. And that's with full respect and appreciation for everything that you have offered.
Thank you. Are there any other questions?
I think I actually interrupted Justice Wecht.
Justice Wecht did have a question.
No, I think you've covered it. Great arguments by both lawyers.
Thank you. Do you need to sum up?
I think the answer to that question is no.
Great. Great answer. Great answer. We understand both of your arguments, and I do want to say for those in the courtroom and those watching on PCN that we heard from two of the finest advocates in Pennsylvania today, and those arguments were outstanding. So thank you both.
Thank you, Your Honor.
We'll call the next case, Mr. Minner.
Commonwealth of Pennsylvania versus Marcus Womack, representing Mr. Womack, Mr. John Eisenberg, representing
We're just going to wait just a few minutes before we begin.
Fine, Your Honor.
Give Justice Doherty a chance.
No, I'm good. Thank you. Thanks. I appreciate it. Can you? Again, you do. Yes. Yeah, truly. Truly.
Yeah.
We're just going to wait for Justice Doherty and Justice Mundy. That way you'll both have a shot at a 6-0.
Or 3-3.
I'm just glad to see we cleared the courtrooms.
Just for fun, as soon as those two walk in, let's just get up and.
Just wait for Justice Mundy and we'll get started.
I think so. No.
Mr. Minner, would you call the last case?
Commonwealth of Pennsylvania versus Marcus Womack, representing Mr. Womack, Mr. Taylor's issue, representing the Commonwealth, Mr. Donald.
In this appeal by allowance, we must determine whether for purposes of a defendant's right to a speedy trial under Rule 600 of the Pennsylvania Rules of Criminal Procedure, the start date for a criminal case in which two similar complaints were filed months apart is the filing date of the first complaint or the second complaint. Good morning.
Good morning.
Oh, good afternoon.
Sorry. And Madam Chief Justice, and may it please the court, Your Honors, the answer to the question currently before the court should ultimately have come down and should come down to whether the Commonwealth exercised due diligence throughout the prosecution of Mr. Womack's case. As is clear from past cases before this court and remains true today, unfortunately, Rule 600 does not speak to how the run date is to be calculated under any two complaint scenario. However, a key aspect of Rule 600 is whether the Commonwealth exercised due diligence, a key aspect that is in terms of how the run date is to be calculated. Indeed, Rule 600C1 provides that delays caused by the Commonwealth are to be included in the calculus when the Commonwealth fails to exercise due diligence. That has been a key aspect of every iteration of Rule 600, and it remains so today on the issue before this court. As such, the lower courts should have required the Commonwealth to have proven by a preponderance of the evidence that it acted with due diligence, not only in prosecuting Mr. Womack on the first complaint that was filed after an extensive investigation that triggered a parole detainer and his pretrial detention, but throughout its use and decision to use an investigating grand jury and then file a second complaint when the second complaint was premised on the case underlying the first complaint.
Well, that's the question I have. So there were 13, now there are 12, right, in the second. I mean, which of those could have been filed with the first complaint? I mean, you do concede, I assume, that there's something in that second set, something out of those 12 that could not have been filed with the first, right? Or not? Am I wrong?
So to address that question, Your Honor, I do believe that what we perceive as the test that the trial court crafted in looking at what could have been filed is too narrow of a test that gives the Commonwealth the opportunity to unfairly extend its ability to prosecute a defendant while not lessening the burdens on a defendant like Mr. Womack, who remained detained on a first complaint that the Commonwealth, in the words of the trial court, knew full well that it had no intent to prosecute. In addition to that, the other interest that Rule 600 is designed to protect, or promote rather, is society's interest in efficient prosecution. And that efficient prosecution is not necessarily aggressive prosecution, but prompt prosecution. By focusing and doing what the Commonwealth did, by focusing solely on what it could have brought at one particular point in time, without examining the fact that the Commonwealth essentially put old wine into a new bottle in the second complaint, it put Mr. Womack in a position where it created confusion. For instance, he had two attorneys appointed for him. He had two separate dockets. In addition to that, there was a docket that was maintained and open that remained untouched in the trial court. And so by focusing specifically on what could have been brought at the time the first complaint was filed, rather than focusing on what the Commonwealth did and did not do that led to the filing of the second complaint, it does undermine the interest that Rule 600 is designed to protect.
Counsel, the trial court, in really a fine effort in terms of trying to work through this complicated issue.
Yes, Your Honor.
As I understand his basic analysis, is he looked at what evidence was available to the Commonwealth at the time the first complaint was filed. And if the evidence was not available to the Commonwealth at that point in time, then he found no problem with those subsequent charges. What should he have done instead of just looking at what evidence was available?
Well, Your Honor, with respect to the determination as to what evidence was available, I think the Commonwealth also in its brief highlights two particular pieces of evidence, and I think this will address your question. The cell phone dump of Mr. Womack's cell phone, that was supposedly new evidence. Well, with respect to Justice Weck's question as to why we should look at what the Commonwealth did throughout the entire prosecution, it was perceived as new evidence. However, Trooper Corll, who was the lead investigator in the case, was involved with setting up and coordinating 3 controlled buys involving Mr. Womack through use of his cell phone 1 month before he was arrested and 1 month before the first complaint was filed. However, Trooper Corll did not obtain a search warrant for that same cell phone that was obtained on the date of Mr. Womack's arrest until 6 months later. And so that is a delay that's something that the Commonwealth, frankly, did not need the investigating grand jury proceedings for and could have, in fact, actually discovered much earlier, given what was uncovered during the course of the investigation leading up to Mr. Womack's arrest in this case.
So you would say the problem with looking at what evidence is available is that it doesn't take into account that that very same evidence was in fact available prior to that point in time. It was just the decision of the Commonwealth not to do anything with the availability, in that case, of the cell phone.
I believe that is correct, Your Honor. And I think to further elaborate on your question, one of the things the Commonwealth addresses in its brief is, well, Mr. Womack received the benefit of the remedy of Rule 600. The first complaint was dismissed with prejudice. Well, true in form, but not necessarily in substance, because the cornerstone of the Commonwealth's case was all of the evidence that it had already investigated and uncovered prior to and contemporaneous with Mr. Womack's arrest. And then on top of that, while the counts might not have been directly aligned in terms of what was filed in Complaint 1 versus Complaint 2, the Commonwealth still charged Mr. Womack for the same period of time that he was charged under the first complaint.
Counsel, what if any, and I'm not sure there is any, but what if any significance should we give to the point about the separate independent prosecutorial authorities, the district attorney versus the attorney general, their jurisdiction, their powers, should play into this idea of the Commonwealth, which you keep hitting? How should that play into this calculus, if at all?
I'm sure the court is aware, the trial court too led off the post-sentence motion hearing with clarifying that in the court's view, these two distinct prosecutorial entities all actually serve the same sovereign. I would also point out that while the first complaint was still pending, this was not a situation where the DA's office in this case completely backed off and turned over all control to the Attorney General's office. In fact, after the second complaint was filed, as the trial court highlighted, the Attorney General's office failed to complete the basic task of almost timely filing the criminal information. The DA's office, the same DA's office that was involved in filing the first complaint, to beat that deadline, actually had to step in, coordinate with the AG's office to file that criminal information.
So I think you're giving me additional facts, which is great. I'm just wondering, from a legal principle and application of Rule 600, should we apply it regardless of whether the second complaint was filed by an independent, or not independent of the district attorney, still representing the same party, but an independent investigatory and prosecutorial authority? Is that a factor, or should we just interpret it doesn't matter who the prosecutor is, whether it's the DA in Blair, the DA in Huntington, every prosecutor has to be cognizant of the time period that the prior prosecutor started to run?
I would say the answer to that, I would answer that question, yes, Your Honor, that it should be focused on the Commonwealth generally, not the prosecutorial entity, especially considering that, like in this case, I know it's another fact, but it was the DA's office that referred the case to the Attorney General's office. So the Attorney General's office here had access to not only the lead trooper in the case, who they ended up using at the investigating grand jury, but all of the evidence that that trooper had uncovered leading up to Mr. Womack's arrest.
Counsel, if I may, in this particular case, the trial court held that the second complaint could not have been brought at the time of the first complaint, those charges, I should say. With that factual finding and credibility finding, wouldn't we have to overrule that in order to grant you relief? And if so, why?
I believe you're referring to what standard
Yes.
also should be applied. Well, the actual question presented in terms of how to calculate or when the Commonwealth gets the benefit of the second run date is a legal question as to how the Rule 600 should be interpreted. So even though the trial court may have found that it could not have been brought in, that was a factual finding that was a result of the test that it crafted. So I still believe as under a de novo review, the court should review the trial court's legal determination that the focus should be at the time the first complaint was filed, what charges could have been brought.
About the fact that the first case against your client was discharged and he received credit for time served on the second. Why isn't that a proper form of relief?
Well, speaking first to the time credit, Rule 600D is clear that the remedy for a Rule 600 violation is dismissal with prejudice, not time credit.
Now, that's the second case.
Correct.
The 600 applied to the first complaint because it exceeded.
Correct. And again, in form, yes, he received a dismissal with prejudice of that first complaint. But again, the concern, going back to my initial comments on the interest to be protected, by focusing solely on the first complaint and not giving due course or having the Commonwealth prove why it was reasonable to submit this case all the way through to a presentment before an investigating grand jury, that's something that the court should have required the Commonwealth to prove as part of its due diligence.
Isn't that a matter of prosecutorial discretion?
Yes, it is, Your Honor. Your Honor, the Commonwealth, and we're not advocating that the prosecutors or the Commonwealth cannot submit a case to an investigating grand jury. However, doing what they did here, what the Commonwealth did here, by using the first complaint as a placeholder to put Mr. Womack on ice when there were other reasonable measures that were ongoing, that even the Commonwealth concedes in its brief that it could have done, such as accelerate his prosecution, while it is up to the prosecution ultimately as to what investigative measures to use, the Rule 600 clock is still running when someone is formally accused of a crime through the filing of that first complaint.
Can I come back to that clock issue? Because I'm still unclear on whether it's your view that that Rule 600 would require dismissal of all charges, or do you concede, and I'm not saying you do, I'm just asking, do you concede that it can be applied on a charge-by-charge basis? This goes to my earlier question about overlap, or the possibility of overlap, or the extent of it, I guess, because the latter would suggest that we need to do a deep dive into the record here and really drill down and like the Venn diagram point, from earlier, or is it all or nothing?
So our position is all or nothing. I will say, however, that we would concede to the extent that's the extent the court would be willing to go on a charge by charge basis. We would be open to that. However, our position is that all charges should be dismissed. Again, so the Commonwealth is not put in a position to not only do this to another defendant, but unfairly seek extensions of time while it has not demonstrated what it has done in the meantime and acting reasonably to bring that individual to trial.
And just a brief follow-up on that point. Should we agree with you that the remedy would be complete dismissal? Would it be required, in your view, for such a ruling to find some sort of bad intent, for lack of a better term? That's maybe a little strong, a little like the placeholding, putting on ice, that sort of conduct. Is that an element of the remedy you're seeking, or is that not a requirement of the standard you're looking for?
Your Honor, I believe that would play in just to the due diligence analysis. And again, the rule solely speaks to, obviously, due diligence. However, I do believe, however, in assessing due diligence, whether or not the Commonwealth did act in bad faith could certainly play into an ultimate finding as to whether due diligence was exercised. But I don't necessarily believe there has to be a finding of bad faith. It's whether the Commonwealth acted reasonable or not.
Are you alleging bad faith?
Your Honor, in full candor to the court, I'm not aware of any. To answer your question, Your Honor.
You're agreeing with me that your problem is what looks like the apparent presumption on the trial court's part that the Commonwealth used due diligence in procuring that evidence, so that the date he's using for when they had the evidence is the earliest date they could have had that evidence.
Well, Your Honor, I don't necessarily believe the Commonwealth presumed that the Commonwealth acted with due diligence.
The trial court.
The trial court. In fact, the Superior Court even went so far as to say that due diligence was irrelevant here, even though the rule speaks to due diligence. So does that answer your question then, Your Honor?
All right, any other questions from the court? Do you want to sum up?
Your Honor, the only thing I would say at this point is we respectfully ask the court to reverse the judgment of the Superior Court, vacate Mr. Womack's judgment of sentences, and discharge him. Thank you.
Thank you, Mr. Michaud. Mr. Eisenberg, our last advocate of the day.
May it please the court, Ronald Eisenberg for the Commonwealth. Your Honor, the defense position today and throughout has, to some extent, sounded in this court's prior holdings in Campana and Hewed and the nature of the relationship between the first case and the second case. But I'd suggest that what they're really advocating for is more of a super Hewed standard where the prosecutor, at pain of a Rule 600 dismissal, must charge every possible crime as early as possible, as many crimes as possible, and with as little evidence as possible. And I don't think that that's something either that Rule 600 requires or that this court would want to require, a rule of requiring prosecutorial overcharge.
Well, in fairness, I thought that Mr. Michaud was saying that some of the evidence was actually available and had just not been tapped into.
Yes, Your Honor, and I really think the answer to that is the prosecutorial discretion question. There was a large body of evidence here, and the manner in which it was looked into, the manner in which it was developed, the timing of all of that is not a simple question of looking at a particular piece in isolation on a particular day.
Doesn't the due diligence standard, counsel, require us to look at what could have been brought with the first?
Your Honor,
even if they don't get, the outright dismissal and everything, aren't we compelled by the rule to look at what could have been brought?
Your Honor, I think that position actually jumps the gun. The threshold question here is whether the second complaint is treated as the first complaint for purposes of the Rule 600, 365-day requirement. If it's not, of course we're allowed to investigate a case and should investigate as thoroughly as possible before we bring charges. So that's the trick here. When the defendant argues that we have to look at the Commonwealth's due diligence in the second case before it even was brought and before all the evidence was developed, we're dramatically changing the nature of Rule 600 from a speedy trial claim into a speedy investigation claim. And in fact, I think the facts are essential here because I think the points made really are a vast oversimplification of what was before the prosecuting authorities. This investigation, this grand jury investigation, involved 34 different participants. 34 people were charged. There were dozens of witnesses before the grand jury, dozens of grand jury subpoenas that were issued. And there is just no possible way that the Commonwealth could have done all of that on October 6th, 2017, the day that this search warrant was first served on this particular defendant. When they walked in that day and found him sitting with a pile of drugs worth thousands of dollars, heroin, fentanyl, cocaine, and a gun, they knew that he had done that on that day. They had evidence with which they could charge. But they did not have evidence properly sufficient within discretion to go after this entire operation. They knew there was an operation. They had heard from a confidential informant that people were coming in from Philadelphia and selling. But you don't charge on that basis. You investigate on the basis of that sort of confidential information, and that's what the Commonwealth did. I think there's been perhaps an overstatement of what those first charges really were. The complaint in the first case was based on that single day of possession, the possession with intent to deliver charges, all the charges, the particular gun that he had that day, were all charged for that specific day. There had been information gathered before then, some. There had been a few controlled buys from this defendant, but those controlled buys were not charged in this complaint. They were part of the probable cause for getting the search warrant, but they were not part of the affidavit of probable cause for the criminal complaint, which was limited to that day. Now, contrast that with what actually happened when the charges were brought the following year after a 10-month grand jury investigation. As I said, huge numbers of people were arrested. There were many witnesses, many additional charges that, for example, use of a communication facility, that spanned a much larger period of time than the particular day when they arrested him on October 6th. He had a cell phone on that day, but he wasn't using it on that day. You couldn't have charged him with communication facility because he had a cell phone in his possession with the drugs. What the evidence developed was financial records, testimony from numerous informants and buyers and other players in the operation. And the defendant, by the way, was not the center, the core of this investigation. He wasn't the biggest fish in this sea. That was another guy. This defendant was second tier, along with a number of other second-tier people that had come in from Philadelphia. And all of them were the focus. This was not, let's get the defendant this time and let's get him next time. We not only didn't need the first charges in order to detain the defendant, we didn't need to detain the defendant in all in order to conduct this investigation. And in fact, most of the people in the investigation were not detained. They were not arrested on some other charge and kept in jail. And usually when we conduct investigations in the grand jury or otherwise, we're usually investigating people who are not in custody.
But this gentleman was in custody.
He was, and the reason he was in custody was because of the detainer, the state parole detainer. This was not his first ride. This defendant was a career armed drug dealer who had a number of prior convictions in Philadelphia. He got out, he had a state sentence on this most recent Philadelphia conviction. He got out of prison in 2016, promptly picked himself up, moved out to Huntington, and started helping to operate this new drug organization there.
But the parole detainer was because of the criminal charges.
Well, the criminal charges make the parole detainer easy, Your Honor, but absent the criminal charges, there would still have had to be a parole
Why would there have been a parole detainer in the absence of criminal charges?
Because parolees are not allowed to have thousands of dollars of fentanyl, heroin, and cocaine in their possession, along with guns that they are prohibited from possessing.
Yep.
Those are parole violations.
Well, of course they're parole violations, but they would the detainer issue here was based on the criminal charges. It was not based on a detainer lodged by the board because he was found with.
That is true, because they wouldn't given the charge, but it had.
And he would have been entitled to a parole revocation hearing and all that other stuff on the subject of his possession, but that didn't happen because it was being held simply because of new criminal charges.
That's correct, Your Honor.
But your point is he could have been held.
That's correct, Your Honor. And in other words, the point is the first charges were not used for the purpose of trying to keep him in prison. We didn't need him to be in prison. And the
well, that's a factual issue, right? The intent.
Well,
isn't that a factual question as to?
I think it's
even to the extent that it's relevant. It's a factual question.
I think it's certainly an obvious inference from the record and from the investigation as a whole. But I think you were right that factual findings are crucially important here, and the judge made those. He went through the charges in a very detailed fashion to compare the new charges with the old charges. As I've said, the first charges were much more limited than we've been led to believe. So far, they were
I didn't hear you. The first charges
were much more limited than presented. They were limited to that one day when the first search warrant was issued against him. And yes, the investigating trooper knew some things before that time, but what he testified, and there was a hearing that the judge conducted before making his fact findings, a post-trial hearing on my colleague's post-sentence motion, at which my colleague was present to cross-examine the trooper. And what the trooper testified to is that most of the information that was part of the larger investigation was based on interviews that he conducted after October of 2017, when the local charges occurred. And he testified that many of those witnesses testified in front of the grand jury, and subpoenas were issued, and search warrants were issued. And my colleague has argued, well, they didn't have to do all of that stuff. They didn't have to go to a grand jury. And the fact is, as a preliminary matter, the drug dealer doesn't get to tell the Commonwealth how it's going to investigate his drug dealing. But, of course, there are reasons why grand juries exist and why they're useful. Yes, we prepped those witnesses before we went into the grand jury and therefore knew that they were saying something to us. But to get their testimony under oath and on a transcript is a valuable thing, not just for the prosecution, but for the public at large. Subpoenas cannot be issued by prosecutors on their own. There's no general subpoena power entrusted to prosecutors. That comes only through the grand jury. That was crucial information in this case. And as a result of that careful gathering of all of that information, 32 of the 34 people charged had their cases resolved without trials through guilty pleas because of the overwhelming evidence. There are only 2 that went to trial. Now, it's a good thing for not just for the prosecution, but for the public when the evidence is shown to be strong, when we do our job of developing the evidence properly. And the length of time, the record shows from the post-trial hearing, the length of time for that grand jury hearing was, for that grand jury investigation, it began in December of 2017 with the first evidence presented, and it was over with the issuance of a presentment in October of 2018. 10 months. I know that Judge Zanuck, who I know well and have the greatest respect for, was impatient with that amount of time, and I understand that, and I understand that he has been a strong advocate for regional grand juries that local DAs could use on their own. I totally agree with him on that. But the truth is that this was not a particularly long period of time for a state or, for that matter, for a federal grand jury investigation. Although Judge Zanuck was concerned that this case, Little Huntington County, as he put it on the record, was having to compete against all the other counties for grand jury time, the real competition was among our own lawyers because we just have so many investigations that come before a grand jury. And this particular one was approximately 50 different investigations. So it takes time to marshal those witnesses, get them in, have the time to put them before the grand jury, issue your subpoenas, get your returns on those subpoenas, go through all of that information. He testified, the trooper, that as to the Facebook information, he had to review 17,000 pages, web pages, in order to complete the investigation. He had to review hundreds of hours of prison calls and videos that were on the defendant's phone, all of which led him to, and led the Commonwealth to understand that this was something much bigger than they knew on that day. This defendant, it turned out, had a whole arsenal of weaponry, from semi-automatic handguns to assault weapons with extended clips. He had videos of himself handling those and shooting those weapons. This was not simply some local guy selling marijuana. This was a major undertaking, and it took time to do it right. And I think the judge was correct in concluding that the differences between the first case and the second case were sufficient that the Rule 600 deadline should not be deemed to run artificially from the time of the original.
Mr. Eisenberg, I think we all understand the case. Are there any questions from the court? Do you wish to sum up?
I think the answer to that question is no, Your Honor.
That's an excellent answer. Thank you both. Very,
Mr. Eisenberg?
very well done. All right, I'd like to, before we adjourn, thank our court security, Mr. Shovlin and Mr. Evans, for looking after us, and I'd also like to thank the Philadelphia Sheriff's deputies and the Philadelphia Police Department for all their assistance with security in the courtroom. And I'd like to thank our prothonotary, Ms. Gorman, and our court crier, Mr. Minner. Thank you all very much.
You can stop crying. You can stop crying.
Oh, thank you so much.
Thanks,
I
Mark.
appreciate it.
Thanks very much.
Take care, just a question. You as well. Drive safe.
Oh,